हम पैसा देंगे गाड़ी न था से आने
capture because let us spend time in SFT orders.
May I pardon the question?
Yes, please.
On behalf of Sir Prustic, item 18. Kindly taken up 1 week after or 2 weeks after, my lord.
My lord, I'm appearing for the opposite party in item 18.
Yes.
Lord, on behalf of Mr. Dheer,
Yes.
Lord, I pray that this may come serially. Mr. Dheer is to appear.
Okay.
My lord,
Your
Mr.
name, madam?
Prusty is out of
Mishra.
station, my lord.
Anvesha Misra.
My lord,
Again?
Mr. Prusty is out of station. He was going to.
ठीक ठीक ଅଛି ତ ସେ ତ ଅବଜେକ୍ଟ କଲେନି ମୁଁ କାଇଁ ଅବଜେକ୍ଟ କରିବି ଆପଣ ତାଙ୍କୁ ଆପଣ କଲିଙ୍କ କଥା ଶୁଣୁନାହାନ୍ତି ସେ କହିଲେ ଯେ ଲେଟ୍ ଇଟ୍ କମ୍ ଇନ୍ ଇଟ୍ସ ଓନ୍ ଟର୍ମ ଆସୁ ସୋ ଦ୍ୟାଟ୍ ମିଷ୍ଟର ଧୀର ୱିଲ୍ ଆପିୟର
My
ଆପଣଙ୍କ ନାଁ ସାର୍ ଭୁଲିଗଲି ସରି
Subhash Chandra Mishra.
ୟେସ୍
Item 15, my lord.
Oblige.
Item 15, my lord.
Pardon me.
ପ୍ଲିଜ୍
Lord, may not adjourn it today. My lord, may let it come serially. Lord, I've
ସେ
been.
କହୁଛନ୍ତି ତାହେଲେ ରିଚ୍ କରିବା ପାଇଁ
Let it
Mr.
reach.
Prusty is out of
ସେ
station.
ଗୋଟେ ଡେଟ୍ ନିଅନ୍ତୁ because you have to accommodate that also individual difficulty of a lawyer has to be someday Mr. Dhir will be in difficulty he will seek adjournment please appreciate this short adjournment ନିଅନ୍ତୁ ଗୋଟେ ଡେଟ୍ definite date କରିଦିଅନ୍ତୁ ନହେଲେ week commencing short date କରିଦିଅନ୍ତୁ
Item 15, my lord.
ଆଜ୍ଞା week commencing 2/2 ହେଲା ମ୍ୟାଡାମ ମିଶ୍ର 2/2 usually ସେ ମଣ୍ଡେ ଆସିବ ବଟ୍ ଯଦି ଟ୍ୟୁଜଡେ ଥିବ ଫାର୍ଷ୍ଟ ଡେ ତାହେଲେ ସେମିତି ଆସିବ ଦ୍ୟାଟ୍ ଇଜ ଦ ପ୍ୟାଟର୍ନ ଆପଣ ଅବଜେକ୍ସନ କ'ଣ ମ୍ୟାଡାମ ଜାଣିଛନ୍ତି
My lord, he had specifically instructed that he is to appear in the.
no I mean what is
There
the
were previous adjournments were there, my lord. That is the reason why.
stay ଅଛି ବୋଧେ ଆଉ stay ନେଲା ପରେ ଆର୍ଜନ କରୁଥିବେ ଠିକ ଅଛି
My lord,
ଆପଣ ଆର୍ଜନ କରନ୍ତୁନି I'll note her objection ହେଲା
Mr. Prusty is out of
ସେ
station.
ସାର୍ ଆପଣ 3 ଥର କହିଲେଣି ମୁଁ ବି କହୁନି he's in station
To
so I also agree with you
ବାପାଙ୍କର ଅସ୍ଥି ବିସର୍ଜନ
whatever they
କରିବା
do sir ଏଥିରେ କେସ୍ ର ଅସ୍ଥି କେମିତି କରିବେ ତା ସାଙ୍ଗରେ
ଡେ ଆଫ୍ଟର ଟୁମୋରୋ
ସେ ତା ସାଙ୍ଗରେ କେସ୍ ର ଅସ୍ଥି ନେଇକି ବିସର୍ଜନ କରୁଛନ୍ତି କି ଆପଣ ଆର୍ଗ୍ୟୁ କରିବେ ନହେଲେ this is not a ground
ନାଇଁ
this is the impossible ground you are saying once you file wakalatnama you must understand it we are being watched sir we are being watched by the entire world the way we are conducting cases
Lord, we have filed an objection to the IA as well. That is to be heard today.
yes
Item 15, my lord.
to shoot
ଦୁଇ ରେ କର
Item 15.
but her objection will be noted because otherwise they will be misunderstood
Item 15, my lord.
अच्छा से
No,
Nandara.
Nandara.
yes
I pray for 2 weeks time for filing
others you inform
for
for
rejoinder.
whatever ଆପଣ
Yeah.
ଦେଖନ୍ତୁ ଆଜ୍ଞା ଗୋଟେ RPFM ରେ କାଉଣ୍ଟର ରିଜଏଣ୍ଡର କ'ଣ ଅଛି it's a continuing case so I am simply adjourn it 15 କେବେ 2 weeks ପରେ
After 2.
stay ନେଇଛନ୍ତି
Stay ଅଛି.
ଟିକେ କମାନ୍ତୁ ଟିକେ adjournment ଟା
No, yeah. I am paying the,
ଆଜି କରନ୍ତୁ
today the matter is listed for the IA.
whatever sir
That IA is infectious now.
whatever so it is better you should argue your infectious matter so it can be disposed of instead of adjourning it by 2 weeks call the list
Just I will file a simple rejoinder.
no not your matter item 1
Item 1.
I may pardon, my lords. I may be pardoned, my lords. Am I
Yes,
audible?
Mr. Mishra.
My lords, I'm very sorry, my lords. My lord, I have filed 6 IAs. My lord, in ESI matter, my lords. Now the ESI corporation has floated a scheme, my lords, for amnesty to avail the amnesty scheme benefit. I have filed IA, my lords.
kindly sir copy on Mr. AP Rai
ଦେଇ ଦେଇଛି ଆଜ୍ଞା ସବୁ ହେଇଛି ଆପଣ ଖାଲି କାଲି
Memo ଦିଅନ୍ତୁ, Mr. Mahanti is not there. Mr. Mahanti has memo ଦେଇଛନ୍ତି।
he has given the list. Your lordship tomorrow
ସେଟା କଣ ସବୁଟା ଗୋଟେ ଦିନ ଆସିବ?
sir ଗୋଟେ ଦିନ ଆସିଲେ ସରିଯିବ Pendency
District ଆଣିବେ ସେ ଏଇ ୱିକରେ କହୁଛନ୍ତି,
ଏଇ ୱିକରେ କୋଉ ଦିନ ଗୁରୁବାର ଦିନ ଦେଇ ଦିଅନ୍ତୁ
ନେକ୍ସଟ ୱିକ ହେଲେ ହବ?
ଆଜ୍ଞା ନୋ ପ୍ରୋବ୍ଲେମ ନୋ 27 ତାରିଖ ଆସୁ
ନେକ୍ସଟ ୱିକରେ କରିଦିଅନ୍ତୁ, ୱିକ କମେନ୍ସିଂ 27 କରିଦିଅନ୍ତୁ ଅର୍ଡର୍ସ।
ଡିପଲି
ଅର୍ଡର୍ସ ନେଇ ଆସିବେ
ଆଜ୍ଞା ଅର୍ଡର୍ସ ଆସିବ ଆଜ୍ଞା।
Mr. Mishra, yeah, sorry, Mr. Gopinath Mishra. Mishra, so the adjournments are also by all the Mishras. Yes, next.
Well, this is again.
They have appeared in the fresh matter by caveat or what?
No, notice has not.
Notice. Okay.
Notice.
Then why it has come for fresh admission?
No, notice has not been issued.
Acha.
And in fact, my lord, the wife has also filed another RPFM for enhancement in which I have already appeared. So both the matters, if can be tagged.
Mr. Gopinath Mishra for the petitioner. Upon one sir?
Gautam Mishra.
Oh, you are also Mishra. Mr. Gautam Mishra for the opposite party. Yes, sir.
Let him appear in my case.
I have filed Vinama, Your Lordship.
You have
In this case.
no
Yes,
difficulty.
Lordship.
Mr. Gautam Mishra for the opposite party, it is it is submitted by the Lord Council for the petitioner that the opposite party wife has filed case number
376 RPFM 376 by
RPFM
20.
376 of 2025 for enhancement of the amount of maintenance granted in 125 or 124?
125.
In 125 CR under 125 CRPC into bracket since repealed. Both the matters, both the present as well as the said matter, both the matters continue. Stop. The present as well as the said matter arise out of the common order. Stop. Accordingly, both the matters to be tagged together. Mr. G. Mishra, Learned Counsel, submits that he has instructions to appear on behalf of the.
Well, he has already appeared. His name.
I'm sorry. He has filed. You have filed
Yes, Your Lordship.
that the G. Mishra. G. Mishra. Both are G. Mishra. Upon Purana.
Gautam Mishra.
Gautam Mishra. Mr. Gautam Mishra, Learned Counsel submits that the Learned Counsel endorses the submissions of the Learned Counsel, Mr. Gopinath Mishra, for the petitioner. Stop. Para, accordingly, both the matters shall be listed on both the matters be tagged and listed on.
Se matter ta 2 ku fix is.
In the week commencing 2 kar do chho. Tale
Yes, Lordship.
problem hobani ho. In the week commencing 2. Here, Mr. You talk to your senior, he will settle it, arrive at a sum. Please.
376 by 25 RPFM.
Upon RPFM 376 of 2025. See order they लिखी upon भी लिखी दे.
Grateful.
Item 2.
So Raghuda.
May I please? This case, my lord, the petitioner, the husband, my lord,
Yeah.
challenge the, my lord, 125, my lord, judgment, my lord, passed in favor of the wife, my lord, and awarded 15,000 to the wife and 5,000 to the son, my lord. And in fact,
Deposit it.
my lord,
Deposit.
my lord, deposit,
Or I'll dismiss.
what happened in this
Unless
case, my
you
lord?
deposit,
My lord,
if you go through the 125 or the present 144,
my lord.
there is very little scope of interference in appeal.
Exactly, my lord. But in fact, my lord, that under appeals court judgment, my lord, Rajneesh versus Neha, that has not been.
Which paragraph in Rajneesh versus Neha applies to
90, paragraph 90, my lord.
9125. Read it.
No, not 125, but maintenance, so for maintenance concerned. And here, my
I
lord,
don't make my order vulnerable. You are sufficiently senior.
my lord,
If I will rely on you, my order will be thrown by the Supreme Court.
my lord.
I cannot rely on Rajneesh versus Neha in deciding 125.
Not 125, but that is
Section
unacceptable.
9.
But exactly, my lord.
That is sorry.
TV
Section
Act.
25.
My lord. Here man 25, but in fact man the law trial court man is the
ସାରନ୍ତୁ
Malord.
ଆପଣ କଣ ଜମ୍ପ କରି ପଳେଇଲେଣି ଫେରେ ଆପଣ କହିଲେ ରଜନୀଶ ବର୍ସେସ୍ ନେହା ଫଲୋ ହେଇନି ଟ୍ରାଏଲ କୋର୍ଟ ଅର୍ଡର ଇଜ ଭଲନେରେବଲ
That is not
so which paragraph of rajneesh versus neha
Malord.
takes care of 125
125 not Malord. Absolutely correct Malord.
ଆପଣ ତ ପଢିଛନ୍ତି ମତେ କାହିଁକି ଏମିତି କହୁଛନ୍ତି
ମୁଁ କହିଛି
ମୁଁ
ନା।
ଭୁଲ ଅର୍ଡର ପାସ୍ କରିଦେବି
ନାଇଁ
ବହୁତ ବଡ ଖୁସି
notice will go to her Malord. 5 lakhs.
unless you deposit the amount
Some upon will deposit.
some amount ନୁହଁ
1 lakhs per
ଅଧିକା ବି ନୁହଁ ଆପଣଙ୍କର ଯେତିକି ଡ୍ୟୁ ଅଛି ସେତିକି ଡିପୋଜିଟ୍ କର
5 ଲକ୍ଷ କେତେ ହଉଛି ଲକ୍ଷ ଟଙ୍କା ଡିପୋଜିଟ୍ କରୁ 20,000 ଆର ଇନକମ୍
5 ଲକ୍ଷ 20,000 କି ଆଜ୍ଞା 2,000 I am not concerned
Malord.
in many of the cases to the kindly listen
Correct.
allow the court to complete
Correct.
the problem is 125 and section 24 petitions are argued as if it is a permanent alimony petition the courts are also adjudicating like that
Right.
but there is no scope
No scope. Final judgment.
5 ଲକ୍ଷ ଜାଗାରେ ଆପଣ ଲକ୍ଷ ଟଙ୍କା ଦେଲେ କେମିତି ହବ
ଦେବୁ ଆଉ ଇନଷ୍ଟଲମେଣ୍ଟ ଦେବୁ
ଆପଣ ଏରିଆରେ କେତେ ଦିନ ହେଲାଣି
ତାର ହେଇଛି ପ୍ରାୟ
I will attach his salary
ସାଲାରୀ ପ୍ରାଇଭେଟ ଇଏରେ
private ହଉଛି public
20,000 ଟଙ୍କା ମାସକୁ ପାଉଛି
କୋଡ଼ିଏଟା ପୁରାଟା କରିଦେବ so that he will realize
20,000 ବି କରିଦେଇ
he will know how to survive without money the
ଅସୁବିଧା
same logic
ଆକ୍ଚୁଆଲି ଅସୁବିଧା କଣ ଇଏ
ତାଙ୍କର 20 ଟଙ୍କା ଦରକାର ଅଛି ନା ନାଇଁ
ହଁ 20 ଦରକାର
ଦରକାର ଅଛି so then what about Mr. Bragad then what about other human beings
Malord exactly Rossi
Child-
I am also Malord agree with your Rossi view
Sir,
but in fact Malord I want Malord the
I totally agree and
he also Malord wants to take out the wife ki ଆଉ ଝିଅକୁ ନବାକୁ ଚାହୁଁଛି
after he deposits the money
Malord.
they will take care of him now you hand over the 20,000 to them they will be asked to take care of the person
Malord one thing Malord he will deposit 1 lakh rupees monthly current monthly ଦଉଛେ
ଆପଣ ଆଗ
so that ସେ appear କଲା
ଆପଣ ଦେଇନାହାନ୍ତି 25 ମାସ ହେଲା so 25 ମାସ ଯୋଉ ଡିପ୍ରାଇଭ୍ କରିଛନ୍ତି for on that reason alone it should be dismissed there is not a single order of any court much less Supreme Court or High Court
125
that he is not appellate authority so called Supreme Court
ହସିଆର ନାହିଁ
Supreme Court କଣ ନା କଣ ସେ କାଇଁ ଷ୍ଟେ କରିଦେବେ 125 order ଟା
ଷ୍ଟେ କରିବା ନାହିଁ
ସେ ଜଜଙ୍କର କିଛି ଇଏ ନାହିଁ ତାପରେ ଆପଣ ଏଠୁ ଫାଇଲ କଲା ପରେ you take a plea that High Court is sitting over the matter
ଆମେ ଆରପଟେ ଥିଲେ ବି ସେ କଥା କହିଥାନ୍ତି
this has become a fashionable litigation
one thing
ଯଦି ଆପଣଙ୍କର capability ଅଛି 10,000 ଦେଲେନି why you are violating the decree
he is residing at Calcutta
wherever you reside
only because due to communication gap between the advocate his advocate and his fellow for that reason all this
he's now communicating so well with you you advise him I am not interfere how much time will take to deposit 5 lakhs
simply notice जाओ 30 तारिख
notice for the dismissal ଚାହୁଁଛନ୍ତି I today I will dismiss
I will take instruction Malord କେତେଟା ଦେଇ ପାରିବ
violating এটা কত নম্বর এটা
2 আর্জন কত নেক্সট ইনস্ট্রাকশন নেই দেব next
the petitioner husband is before this court challenging a order passed by the Lorded Judge Family Court Jajpur in a petition under section 125 of criminal procedure Mr. Ragada, this determination of not pay has to be tested with the power of the court. Judge Family Court is not useless court, so that his decree is thrown. You must understand that. This, at your level, at least you have sufficient standing in the bar to tell the client. A youngster will say, I guess a brief poleva.
Exactly. କିଛି ନାହିଁ ତ ଡିପୋଜିଟ୍ ପଇସା କହିଦେଇଛି just time ଟେ ମାଗୁଛି
Sir, we are frustrating actually.
You will deposit my lord. Deposit my lord. But in fact, I will take instruction from him. He will deposit.
Sir,
trial court deposit kare
here is a case where he should be arrested. Like that directly.
ନିଶ୍ଚିତ warrant.
I will not examine apart from examining Rajneesh versus Neha, where arrest and detention has been directed by courts. Those cases also you cite.
ଏଇଟା ତ warrant ହେଇଯିବ ନିଶ୍ଚୟ
This is not a way to do it. Court decrees.
କେତୁକୁ ଅଛି ଲୋଅର କୋର୍ଟରେ ଅଛି କେସଟା ଏ ଶୋକଜ ମାଗିଛନ୍ତି ଯୋଉ ଏକ୍ଜିକ୍ୟୁସନ
This is really a sad situation.
I also my lord similar view with your lordship my lord.
No, correct.
ଝିଅ ପିଲାଟା ଅଛି ସ୍ତ୍ରୀଟା ଅଛି
କଣ ଲେଖିଲେ Stop. The petition under section 125 CRPC into bracket since repealed was filed by the wife in the marriage. That is CP number 121 of 2023. The petitioner is in gross default and violation of the judgment dated 25/6/2025. On being asked, the learned counsel for the petitioner submits that the petitioner has not deposited any amount towards satisfaction of the decree, nor at present has deposited any amount before this court to secure the decree, which is in the nature of a money decree. The learned court, while considering the petition, has observed thus has dealt into the aspect of the income of the opposite party as well as the petitioner wife in the said petition. The relevant paragraphs of the said order are reproduced in paragraph 5, 6, and 7. Para 10 and 11 कर दे, para 10 and 11. Prima facie, this court is of the opinion that the order passed by the learned court is reasonable and not inclined to interfere. However, being persuaded by the learned counsel for the petitioner, the matter is adjourned. It is submitted that the petitioner is employed in a private company. The petitioner filed affidavit giving the details of his employment, details of his salary statement, his present address, indicating the police station by the next date. List under the same heading.
We commencing doing.
We commencing doing.
Item 3.
May I please? Your Honor, the wife is before a lordship for transfer of the CP proceeding filed by the husband before the judge family court Cuttack to judge family court Bhubaneswar, my lord.
कटक भुवनेश्वर कौन डिफरेंस अछि
मतलब
आपन असुविधा होछि जीवासे करियो ना कोन
मतलब actually thing is that मतलब in the meantime the wife has lost her mother and father, my lord. There are no male members in his family.
How does it help to go to Bhubaneswar?
मतलब तांग घर की भुवनेश्वर मतलब.
So you must understand now, if I pass such order,
मतलब
I have to record this. Will my order be sustainable?
मतलब
Because there is no male member in the family, the matter should be pursued at Bhubaneswar instead of Cuttack.
मतलब I
Because
understand.
now Cuttack and Bhubaneswar is known all over the world now.
I know, my lord.
So it is challenged in Supreme Court.
Only a distance of 30 kilometers. But the thing is that
Not 30 kilometers.
Malat, she is with a minor daughter also.
Sir, certain places in Bhubaneswar as farther from Cuttack.
Malat,
This logic would be ridiculous.
Malat, Malat, it was
Then
a.
why you are saying this? And you stay in Cuttack or Bhubaneswar?
Malat, the wife stays in
ଆପଣ ନିଜେ personally କୋଉଠି ରହୁଛନ୍ତି?
ମୁଁ କଟକ ମାଲ.
ତ କେମିତି ଏଗୁଡ଼ା କହୁଛନ୍ତି? ଆପଣ ଯଦି ଫରେନ୍ ରୁ ଆସିଥାନ୍ତେ ଆର୍ଗ୍ୟୁ କରିଥାନ୍ତେ
I understand, Malat.
what is this logic you see whenever you are arguing it should be a sensible argument factually.
I Malat totally understand.
It is factually insensible and legally unsustainable.
Only in
And you
the
are assisting me to pass that order.
no, Malat, on the interest of
Clear at least.
Malat,
When you make an empty statement in a court, at least it should sound some logic.
The only thing is that, my lord,
what is this? Now we will discover that she is receiving maintenance 24 ରେ କେତେ ପାଉଛନ୍ତି?
no, lord, there is no maintenance right now.
Maintenance ରକ୍ଷା ହେଇଗଲା।
ମାନେ ହେଇନି କିଛି ଯାଏ।
ତ ସେଟା କାହିଁ କରୁନାହାନ୍ତି କାହିଁକି? Why TRPC? Why not 24 or maintenance? Why it is not filed?
Right now, my
So
lord,
you should also guide her.
Lords, may keep it to next week, my lord. I'll take instruction. I'll withdraw, my lord. Lords, may keep it to next week.
This is item
My lord, 3, my lord.
Item 3.
Mr. S.S. Parida for the petitioner. The petitioner wife is before this court seeking transfer of the CP number 542 of 2025. Should I tell the reason, Mr. Patnaik?
No,
Sorry,
Lord,
yeah,
simply,
Parida.
no, my lord, simply adjourn, my
The
lord.
reason is that High Court, the Bhubaneswar court is overburdened. The two courts, family court 1 and 2.
Well.
If it goes there, that will not appeal to common sense, of course. If the other judges will see, they will laugh at me that he doesn't understand the pendency. In fact, in a, city state like Delhi, it is no distance. But there can be a transfer. Technically, there can be a transfer or not.
Well, I had,
So perhaps that is the reason.
my lord, I had instructed the client, but only upon his interest, her interest, my lord.
Sir, whatever, sir, logical or
My lord, I totally bought on, my lord. I understand.
no, she might have a reason, but that is not legally sustainable.
My lord.
Everything logical is not legally sustainable.
5 ବର୍ଷର ଛୁଆଟା ତାକୁ ଧରିକି ସବୁଆଡେ ଯିବା ଆସିବା କରିବାଟା is
Sir, Bhubaneswar is more difficult. And she should not carry the child to the court.
the thing is that
She should leave her in a crèche. Nale court a crèche କରାଯାଉଛି ସେଥିପାଇଁ.
she is studying in a school right now.
Exactly.
So that is why.
Sir, again, if suppose you show a notice from the court that the child is to be produced, then there can be some logic.
She can't.
You are putting the cart much before the horse, or the horse much before the cart.
What's my urgent, my lord, next week?
Unless she seeks help from her friend or her family or her brother or sister, she can't. She is not supposed to carry the child to everywhere. That is irresponsible on part of a mother.
My lord.
How a 5-year-old child should be carried to court?
The thing is that she
Convince,
can't.
apart from convincing the court, the desperation. What is the reason?
My lord, she can't keep it or anywhere else, my lord. She has to carry her daughter.
No. Sir, she has not come. She is very much in the world, on the earth. This is not happening for the fast couple and the fast child.
Understand, my lord. Understand.
These things are not on. They are completely untenable grounds. From Cuttack to Bhubaneswar. From the court of Learned Judge Family Court Cuttack to Learned Judge Family Court Bhubaneswar. Apparently, there is no plausible reason shown in the petition for directing for consideration of the transfer of the matter, as Cuttack and Bhubaneswar are contiguous townships, and there is no much distance between both the courts. If appearing at Bhubaneswar is convenient to somebody, it would be equally convenient to appear at Bhubaneswar and participate in the proceeding. Para. The learned counsel for the petitioner seeks adjournment. 6 and has adjournment list in the week commencing 16/2/2025. The stay week is na kon.
No, my lord, କିଛି ହେଇନି. ଆଜି first time.
Technique adjournment ନଉଛନ୍ତି file କରୁଛନ୍ତି ବୋଲି TRPC.
No, my lord. Only tomorrow it is posted, my lord.
Sir, do something purposely for the lady and the child.
My lord, I have instructed
TRPC, what you have instructed?
not to go for TRPC, but it was only.
Did I say that? You are not getting also. Sir, more litigation doesn't help a litigant. Focused litigation will help her. She should claim for maintenance.
That
She should
also.
claim for if at all she is entitled, she should claim for transport expenses, daily expenses. Those things will help her.
So maintenance that
Because many cases, these matrimonial causes are getting frustrated because of this. Completely directionless and lack of thought also. Now, I mean, it is just possible that they will be starting filing petition for transfer from Bhubaneswar 1 to Bhubaneswar 2. Because the new premises is closer to my house.
No, not in that.
No, it is not your case in Soro. Somebody is staying in Soro, which is equidistant from Baleswar to Bhadrak. I have dismissed that it should be transferred to staying Soro is part of Baleswar. But the prayer is to transfer it to Bhadrak. The reason is that dita chua achanti. Jadi apanka dita chua achanti, they have to be taken care of. You have to seek help. Yes, next.
Item 4.
Mr. Gajendranath Raut,
May I permit it to
on behalf
move
of
on behalf of
Patnaik for the matter.
On compliance of order of the chair.
The incumbent is the opposite party.
Yes.
It's a quasi-criminal proceeding, so don't make the mistake of implementing a wrong party.
Yes.
Obtain instruction.
Yes, sir. First time.
Mr. D.N. Lenka, AGA for the appearance लिखिए तो opposite party blank third party. AGA seeks accommodation to obtain instruction regarding compliance of the order, which is alleged to have been violated by the opposite party. How much time, Mr. Lenka?
No, can give 2 weeks time.
List in the week commencing.
So hold on.
On जोड़ा comply करिए सेटा comply करी गोटे definite करंतु. Let us not be tentative.
Here the direction was for to dispose of the representation.
तल तो आपण during pendency भी करी परिवे.
So that's why I pay for 2 weeks.
2 weeks कर दें. Please list in the week commencing 23/2/24. Yes, please. Next.
Item 5.
Petitioner challenge judgment order dated
Ms. M.S.P. Dhala for the petitioner.
passed by the Law and Judge Family Court Jajpur in criminal proceeding number 246 by 2024 under section 144 of BNSS, which is dismissed without awarding maintenance to the petitioner.
Yes, take notice. Hard learned the petitioner wife is before this court challenging the order passed by the judgment by the judgment passed by the learned Judge Family Court Jajpur dated 20/11/2025 in CR criminal proceeding number 246 of 2024. By the said judgment, the petition filed by the wife seeking maintenance under section 144 of the BNSS has been dismissed. Dismissed on contest further, on contest. Issue notice along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days. The basic.
2 days.
Aji kurna madam, I am fixing the outer limit. But today it will not be possible because the file cannot be returned. It takes time to complete the order and kali sudha hai pariyo. Order will be uploaded. Within 5 working days. The purpose is that so that the defect again not complied, the matters will be orders it is again listed. Requisite not filed. That should not happen. Within 3 working days for them. Within 3 working days. List after SR, liberty to mention. Yes.
Item 6.
May I please your lords? The petitioner is the husband and the opposite party is the wife. The petitioner is 60 years old and the opposite party is the 51 years old wife. And the marriage was solemnized 25 years back. admittedly, the opposite party wife is a advocate at Baleswar Bar. That is, these are all admitted facts. What has happened? Due to some matrimonial dispute, the wife filed the divorce case as Cuttack Family Court. Husband is the permanent resident of a village which is 25 kilometers away from Baleswar. These are all admitted facts. And the wife has alleged in the CP.
25 kilometers towards Cuttack.
No, towards that side. 25 kilometers Baleswar ku asibaku ta ghara.
Yes.
So the wife has alleged that how she has brought the cause of action at Cuttack, that I am a resident. And the another thing, your lordship may kindly imagine that the father of the wife is a senior advocate of Baleswar Bar, and his house where the wife is allegedly residing is just intervened by a road from Cuttack. I am sorry, from the Baleswar court. She has alleged that after this, during this, before filing of this case, I have shifted to
You have
Cuttack.
said so many times Cuttack, so I start thinking that she's staying in Cuttack.
ମୁଁ କହୁଛି କେମିତି କଟକରେ କହିଛନ୍ତି
Anyway, you take notice.
I have prayed for stay of the ତାଙ୍କର ପୁଣି ମିଶିମାସି ଯିବେ ସାର୍ 25 ବର୍ଷ ଝିଅ ବଡ ହେଲେଣି ସବୁ ସେ ଆଡଭୋକେଟ
ଆପଣ ଟିକେ ଚେଷ୍ଟା କରନ୍ତୁ।
ଚେଷ୍ଟା କରିବି ଏଇଟା 100% କରିବି
ହଜବେଣ୍ଡଙ୍କ ଓକିଲ ସିନିୟର ଆଡଭୋକେଟ
senior advocate Atatran Biswal, you must be knowing, your lordship must be knowing, he is a senior advocate of, and this wife is also I have given her designation what she is she is a permanent resident, but she says that one of the younger sisters in-laws house is at Kanika Chakka and staying here now, which is completely false. She is staying, but only to harass the husband. He is a retired person, ghare ailing person, ghare asi rahuchanti. Se asi Cuttack ladiba is very difficult, my lords. So Baleswar hele tanku basi convenient because she is staying in the father's house, which is just intervened by a road from the Baleswar court.
The petitioner husband is before this court. Seeking transfer of the proceeding, CP number 791 of 2025, from the court of the Learned Judge Family Court, Cuttack, to the Learned Judge Family Court, Baleswar. The said CP has been filed by the opposite party wife, seeking a divorce. 13. Seeking divorce under the section 13 of the Hindu Marriage Act. 13 into bracket 1 of the Hindu Marriage Act, comma 1955.
And dissolution of marriage.
Seeking dissolution of marriage.
Dissolution. Solemnized on 29/6/2001.
29/6/2001. Had learned counsel for the petitioner, it is submitted that the opposite party wife is also resides at Baleswar. The petitioner husband has health issues. He is a permanent resident of Baleswar. And success difficulty in attending the matter at Cuttack. Apart from submitting regarding the merits of the case, it is submitted by the learned counsel for the petitioner that considering the age of the parties, effort is being made for reconciliation. Issue notice along with this order. Requisites for issuance of notice shall be by speed post with registration with proof of delivery shall be filed within 5 working days. List after SR, liberty to mention. IA 13 of 2026. Hard learned counsel for the petitioner. He reiterates his submissions as noted above. Issue notice as above, accept one set of process fee and as well as postal requisites along with the petition. As an interim measure, it is directed the further proceeding in so and so CP
791 of
before
2020.
so and so court, but open lecture shall be adjourned beyond the returnable date fixed in the present petition. The provision for a date कर दियो
commencing 23.
Sir,
दुई का 9 कर दियो shall be adjourned in the beyond 2 March 40.
my lord, then I will appear before the Cuttack.
Take adjournment.
Then I have to file my Bhokalatnama here.
No, without appearance, how can I direct? That is your choice. Whether you will appear or not.
I mean
So I can say interim order
Yes, I
that,
know. The husband will appear and
no, I could not get you actually. You mean to say that I have to pass an order that he will not appear before the
no, I am not saying.
Not
If there is a stay order, then it will be
Sir, that will be
communicated.
staying the profession. Don't seek stay of profession. They
Then
should
I have-
engage you for Kotak also.
Then I have to produce this order to the concerned court. Yes.
Just one. Let me complete actually. I lost track. One minute. Then 2nd March 2025. The registry shall fix returnable date in the issue notice notice issued as above to be 20/2/26. List in the week commencing 23/2/26. So, is he related to you, not paying fees?
No.
So you are reluctant to appear in Kotak. So in Mr. Mohanty, you are not appearing in
My
Kotak.
lord, in
Kotak,
fact,
you should appear. You should engage buyers.
in fact, the husband is they are not solvent party. See, he is staying in a particular
Sir,
place.
if they are not willing to litigate, let them not. But profession cannot be free of cost.
No, that is not.
Last, Mr. Chandrakanta, what is the fee of matrimonial cases in Delhi? He will tell you. ସେ ତାଙ୍କର ପ୍ରଫର୍ମା ପ୍ରପରିସ୍ ଫାଇଲ କରିବେ ଲିଗାଲ ଏଡ୍ ନେବେ ସେଥିରେ କ'ଣ ଅଛି
No,
କେସ୍ କରିବେନି କରିବେନି ନା ସେଟା ନୁହଁ ଆଇ ମିନ୍ ଆପିୟରାନ୍ସ କଥା ପଡିଛି ଇଟ୍ ଇଜ ଇନ୍ ଏ parallel thing nothing to do with this case he is adequately protected you have achieved the cycle
It is adequately protected. More ଟିକେ confusion I became confused ଯଦି stay order ହେଲା କ'ଣ directly communicate ହେଇଯାଏ ତ ଆଉ କିଛି ଦରକାର ନାହିଁ ନହେଲେ ଆମେ appear କରିକି ଏଇଟା ଦବୁ
Item 7.
Item 7, Your Lordship.
Mr. S. Tibarewal for the petitioner. Yes.
Lordship, in this case, I am the husband. I am appearing for the husband, Your Lordship. I am staying in Mumbai, Your Lordship. The wife is staying in Sambalpur, Your Lordship. In this case, what happened? I filed a restitution proceeding in the court of Bhubaneswar, Your Lordship. The wife filed a divorce proceeding in the court of Sambalpur, Your Lordship. Thereafter, ex parte judgment was passed before the court in Sambalpur, Your Lordship, allowing the divorce, which is at page number, Your Lordship, 20. It starts from page number 22, Your Lordship. That is the judgment, Your Lordship. Sorry, Annexure 5, Your Lordship. Annexure 5, page number 35, Your Lordship.
No difficulty. I am not
Lordship.
Kindly call.
Your Lordship. Then I approached before this honorable court, Your Lordship, in a appeal proceeding, Your Lordship. The order was passed, setting aside the ex parte order, Your Lordship. May I just place the relevant part of the order, Your Lordship?
No, not
Your Lordship,
necessary.
what happened since the restitution proceeding was pending, Your Lordship? This court, while setting aside the ex parte decree, noted that since the restitution proceeding is pending in the court of Bhubaneswar, the wife is directed to take appropriate steps for getting it transferred. And if the case is not getting it transferred, the learned court below will take note of it. That was the observation of the Lordship.
Transferred from Bhubaneswar to Sambalpur.
From Bhubaneswar to, she will take appropriate steps for that, Your Lordship. This order was passed in the year 2024, Your Lordship. Thereafter, Your Lordship, she filed a transfer petition before this court in the month of January 2025, Your Lordship. Stay order was passed, but when the
Staying section 9 at Bhubaneswar.
Staying section 9 in Bhubaneswar, Your Lordship. And she was directed to file the requisites for the issuance of notice, Your Lordship. Till date, the requisites were not filed, your lordship. Requisites, after multiple opportunities, the requisite came to be filed, your lordship, in the year, in December 2025, your lordship. But they have been enjoying the stay order, your lordship. Now, when this point was brought before the Learned Family Court Sambalpur is saying that whatever you have to do, you file an IA before the Learned High Court in that Mata case and get a stay order, because I cannot pass a stay order. And in the transfer proceeding,
Stay of what?
Stay of the further proceeding, your lordship.
13 or 9?
13, your lordship. 13.
How the court will pass a 13 order?
That I know, your lordship.
And also you have to challenge the Mata order in Supreme Court. How this court will stay?
That is a disposed of case. IA is not possible, your lordship. That I understand. So
everything is possible, but this High Court, this court becomes functus officio after passing order in MATA.
Yes, your lordship.
To stay the further proceeding.
Your lordship, I bowed down, your lordship. So
this TRPC for transfer of what? 13 or 9?
13 from Bhubaneswar, from Sambalpur to Bhubaneswar.
How can this is directly in conflict with the other order?
No, your lordship. Let me read that part of the order, your lordship.
Yes.
Order starts at page number 64, your lordship.
Yes.
Impugned, para 6, your lordship. I'm reading para 6 at page number 65. Impugned judgment.
Straight away you come to that where the court has directed.
Yes, your lordship.
The wife will take steps for transfer of section 9 to Sambalpur.
I'm reading that part.
Yes.
I'm reading that part. Para 6, your lordship. Impugned judgment is set aside in appeal with direction for remand. The direction is made under Rule 23A in Order 11 Code of Civil Procedure 908. We have ascertained that the restitution case is still pending in the Family Court Bhubaneswar. Considering the transfer petitions were disposed of because there had been judgment in the matrimonial case prosecuted by the respondent in the Family Court Sambalpur, respondent may either defend the restitution case in the Family Court at Bhubaneswar or petition afresh for its transfer to Family Court Sambalpur. On omission of respondent to do either, it must be duly considered by the Family Court Sambalpur, your lordship. So when she has the next transfer petition, I have annexed the orders, your lordship. Stay order has been.
Sir, this court cannot attribute motive for non-filing of requisites.
I
the other difficult part of it.
Lordship.
So this transfer petition doesn't solve, and it is directly in conflict with the division bench order. The division bench directed in appeal,
lordship,
granting liberty to the wife to seek transfer of
lordship,
and you must consider that this restoration is post disposal of the CP.
Yes,
CP was restored,
lordship,
because it was decided ex parte.
Lordship,
it is almost kind of order 9 rule 13.
The restitution was pending, your lordship.
Whatever.
Restitution was pending.
Lordship. You can challenge an MTA, so this is akin to order 9 rule 13 order.
Lordship.
So it has to go to that court only.
Your lordship, there are two lordship.
You must understand.
Lordship, I am submitting a lordship.
No, not submitting. What you have understood, kindly tell me.
Lordship, your lordship is saying that since my submission is, your lordship,
what lordship is saying, kindly say. You
lordship is saying that
stretch it because time constraint is
lordship is saying that this petition is in directly conflict with the order passed in the Mata case, your lordship.
Second part is very important.
Lordship.
What?
That it is in directly conflict with the.
That I have said, everyone, you have also heard.
Lordship.
Second part, what I have said is very important.
Lordship, which part, your lordship?
If there is a restoration of order 9 rule 13,
lordship,
or remand, which court will consider?
That concerned court will consider, your lordship.
So which is the concerned?
Family Court Sambalpur, your lordship.
That. So you have got it.
Your lordship, what happened?
You see, the problem is that not only it is, it is against the law also.
Lordship.
You see, while remanding the matter, I will say that Bhubaneswar will consider.
Lordship.
Apart from that, because unless you challenge that, because in the context,
lordship,
the earlier MAT order is binding on the single judge.
Lordship.
Maybe I don't know, but since Mata I have been sitting since long.
Your lordship has passed this order. Lordship was
party to that.
Yes, lordship.
I'm looking like a fool. You should have told that.
Your lordship, I have two submissions with respect to that, your lordship.
The problem is now restoration has to be considered
lordship
by the court, because then while exercising Mata jurisdiction, you kindly mark that or to 23 that appellate court exercise jurisdiction to remand it to that particular court.
That particular court, your lordship.
And I am a party to that particular order.
Lordship.
So then how can I now direct sitting single that TRPC should be considered?
Your lordship, I have two submissions.
You see, Mr. The difficulty you are saying is correct.
Lordship.
There you are very fair in saying, presenting everything in perspective. But as far as law is concerned,
lordship,
then the restored application has to be considered by that court.
Lordship.
So here, since you are aware of consideration of this TRPC, sorry, aware of consideration of CP on remand, then you can appear there also.
Your Lordship,
So your prayer should be,
Lordship.
Bhubaneswar should be transferred to Sambalpur. Because now what you have done, expertise you have got achieved, then your section 9 was pending. So both section 9 at Bhubaneswar and 13 at Sambalpur disposed of were considered by the earlier bench.
Lordship.
So obviously it becomes directly in conflict.
Lordship, I have two submissions with respect to that, Your Lordship. My first submission is that, Your Lordship, this judgment or this order of the division bench, Your Lordship, does not bars me to file a fresh transfer petition, Your Lordship. It only says with respect to the pending case of the
Sir, you said it is a bar,
Lordship.
but that was passed at your instance. You are arguing in installments. Initially, you come to court,
Lordship.
challenging ex parte decree.
Lordship.
That is allowed.
Lordship.
There, after that, after you get the order, then after some time you come here. Now you say that transfer that from that court to another new court.
Your Lordship,
there is the problem.
Difficulty is that, Your Lordship, I do not want to argue it in installment. What
Yes,
Your Lordship may kindly see the order.
You in the sense the person.
Lordship.
Every day a new gun is there.
Lordship.
So he should have said, at least the court should have considered that.
Then Your Lordship may just pass a direction that if I'll file an application with respect to that, it may be considered. I filed several applications. It is not being considered.
Where it will be considered?
Before the family court, Sambalpur, Your Lordship.
How he will transfer it?
I'm not saying about transfer, Your Lordship. I'm saying about that.
You see, the section 9, section 9 has to be transferred from Bhubaneswar to Sambalpur.
Sambalpur, Your Lordship.
You did not seek transfer of that MATA to Cuttack, Bhubaneswar.
Lordship.
CP on restoration. Did you seek that transfer?
That is a file, Your Lordship. This is.
How can it be? How can it be?
Your Lordship,
you can't take the court by surprise also. If you would have made that submission that since my petition is pending in section 9 is Bhubaneswar,
Lordship.
so 13 be transferred, then it would have been a fair adjudication. After the court decides, after 2 years, you are now blaming the other side.
Your Lordship, it was disclosed between the.
No, please so that you had made a prayer and it was rejected or no order was passed.
Lordship, I have filed the application. I can show that.
Filed in MATA.
MATA, Your Lordship, the execution was pending, Your Lordship.
227 power has to be exercised in MATA, not TRPC power.
Lordship.
You should have, while restoring the MATA, CP, getting order in MATA, you should have made that prayer to the division bench, transfer it to Bhubaneswar. Because you have succeeded.
Your Lordship, but at that moment, Your Lordship, what
this is only a process of staying in Bombay and delaying the matter.
Your Lordship, I am not delaying the matter, Your Lordship. They are not filing the requisite. They are enjoying the stay order. I am not getting the notice. I cannot appear, so Your Lordship. It is not on me that I am delaying the process, Your Lordship.
Forgotten the third aspect.
Lordship.
All the proceedings are within your knowledge.
Yes, Lordship. I am saying
when you approached the court,
Lordship,
it was well within your knowledge.
Lordship.
Before the division bench. That I told you, that's the third aspect. Apart from the first two aspects, your prayer is directly in conflict with the earlier prayer.
Lordship.
Second aspect, whether a single judge, after direction by a trial court, by a division bench to transferring the CP to a restoration of CP, can transfer it.
Your Lordship, the division bench only directed him to take steps. The division bench did not direct him to transfer the.
It is an ex parte decree.
Lordship.
So every time it is restored, it will go to a new court. That is not contemplated in CPC.
It has gone to the same.
You see, either you fall with it or you stand with it. You sought for a restoration of the matter. It was restored. Exercising it is in the appellate powers. So there you should have made a prayer, let it be transferred. 227 would have been utilized.
Your Lordship, it was made, but Your Lordship,
it cannot be. So that is why I'm asking you that suppose now you want, well, this proceeding in Bhubaneswar should be transferred to Sambalpur, but you are seeking a direction for transferring the matter from Sambalpur to Bhubaneswar.
Lordship.
After the order was passed.
Lordship.
Cannot be.
Then Your Lordship, a direction may be passed that if this, let me file an application before the learned family court Sambalpur, taking into consideration this part.
You have to file an application here for transferring, or I will exercise my 227 power and transfer the matter to Sambalpur. You obtain that instruction. Every time I cannot pass in different kind of order treating the same matter. Can you read that order again? That provision.
Then Your Lordship, this their transfer.
Your concept of that after restoration it should be transferred should have been at one go.
Lordship.
That is how I am saying that you are seeking installments, not the lawyer.
Lordship.
प्रथमे से कहले let the Initially, he wants the court granted. Let it be let it be fought before Sambalpur. Otherwise, the court would not have directed. Court would have also considered regarding transfer. Now, after restoration before Sambalpur, you say now the Bhubaneswar will consider it.
Your Lordship,
Then what is the point in
Your
restoring a
Lordship, the
matter?
division bench also made one observation, Your Lordship, that on omission to take steps, it must be duly considered by the family court Sambalpur. Suppose the wife came before this court, filed a transfer petition.
Kindly repeat that.
The respondent may either defend the restitution case in family court at Bhubaneswar or petition afresh for its transfer to family court Sambalpur. On omission of
So that point is well taken. You say that then she files a petition TRPC.
Lordship.
That TRPC is pending here.
Lordship.
So that is to be taken up together at best.
Then it may be, then this TRPC
It has to be tagged. It has to be tagged. But no different order cannot be passed. You see, I cannot exercise review power. I am not appellate court of the MATA, nor have an original power in deciding this matter, because it has been already decided by the appellate court.
Lordship.
Directing it to be taken up. Then what? Then you have to, suppose your argument is to be sustained, then you have to come up with some provision in CPC. Upon restoration, a new court will do the trial. There is no concept of restoration before a different court.
No, earlier.
Even appellate court, that provision to 23 doesn't contemplate a different court. That is your sum and substance of your, the result of your argument.
Lordship. Then that TRPC is posted on, Your Lordship, week commencing 23rd February. Then this transfer petition.
It has to be.
Lordship.
Again, otherwise this will go to another bench and something, now maybe this is the bench.
The order is at
Mr. S. Tibrewal for the petitioner, opposite party, blank. The petition has been filed by you kindly take your seat. It will take some time. The petition has been filed by the petitioner husband before this court, seeking transfer of the CP number 112 of 2023, pending before the Learned Judge Family Court Sambalpur to the Court of Learned Judge Family Court Bhubaneswar. The present litigation is not the first instance. As earlier, the petitioner herein had challenged the ex parte decree passed against him in CP number 112 of 2023 by filing MATA number 286 of 2025. जो एक्सपर्ट जो लिख लेनी देखिए एक्सपर्ट जजमेंट एंड डिक्री डेटेड 25/6/2024 हाँ The said ex parte decree was obtained was passed in the petition filed by the wife by the Learned Judge Family Court Sambalpur during pendency of the CP number 112 of 2023, CP number 867 of 2023, filed by the petitioner, the present petitioner husband, under Section 9 of the Hindu Marriage Act, was pending before the Learned Judge Family Court Bhubaneswar. While approaching this court, the petitioner had brought to the notice of the appellate court regarding pendency of the Section 9 application, that is CP number 867 of 2023, before the Learned Judge Family Court Bhubaneswar. This court, a division bench of this court in MATA, page time, Mr. Tibrewal, page
64, Your Lordship.
64.
Page 64, MATA 286.
By order dated 19/12/2024, had allowed the MATA 286 of 2024 with the following observations, paragraph 5 and 6. ହେଲା 5 and 6 page ରେ ଅଛି 65 66 ରେ ଅଛି ଡାଉଟ୍ ହେଲେ ଜଲ୍ଦି ସ୍ପିଡ୍ ହେଇଗଲା କି ବେଶୀ 65 66 it is submitted stop it is further submitted and brought to the notice of the court that pursuant to the liberty granted by this court in the said MATA, the opposite party wife has filed TRPC number
22 of 25, Your Lordship.
by C,
By C.
22 of 2025,
Lordship.
which is pending adjudication. Notices have been issued.
Notice has been issued, Your Lordship.
Notices have been issued, and the next date of listing is on
23rd week commencing 23rd February.
on week commencing 23/2/2026. Para. In considered opinion of this, had the learned counsel for the petitioner at length. The upare bhi lagti pari na. In kindly take yours. In considered opinion of this court, after the direction by the division bench, exercising the powers of the appellate court under Rule 23-A, Order XLI, Order 41, Code of CPC 1908, for the matter to be considered by the learned court in session, that is the learned judge family court Sambalpur, the said order cannot be further modified. Para. However, in the interest of justice, both the matters shall be both the present TRPC shall be listed along with the TRPC 22 of 2025 in the week commencing 23/2/2026. That is the only solution, Mr. Otherwise, both the cases will be, lingering like anything. More TRPCs, two CPs.
Lordship.
Now, one appeal.
Lordship.
Now two TRPC.
Lordship.
5 cases, there will be more, then SLP, it goes on.
Lordship, had they been taken the proper step by filing the requisite, this would not have been the situation, Your Lordship.
Yes. Asu dekhiye. Hopefully they will now. Yes.
Item 8.
Now, are they serious, Mr. Tibrewal, in the CP? For either for restitution or for contest there? What is your perception? I have dictated the order.
Lordship.
So that you understand the psyche of the parties, why this is happening, why 5 cases for nothing.
It's just an ego issue. What I have.
That's the problem.
That's the
That's the
ego
problem.
issue. That's the.
And the number of cases that they're quite, it goes up to about 5, 10, 13. Number of cases, you never know.
Matrimonial proceeding one after another case.
Criminal cases launched by both the cases,
Yes,
transfer of criminal cases,
Lordship.
then maintenance cases.
My lord,
Yes.
I'm a native of a village near Kendrapada.
Sorry, sir?
I'm a native of a village near Kendrapada.
Yes, sir.
Which
Mr.
is
Surendra Kumar Mishra in person. You are a lawyer also?
I'm a lawyer.
Yes, sir. Please.
Sir. So I have some farmland which I am cultivating myself, and one Bagoda society near
Sir,
Kendrapada.
this is my, first of all, is it my jurisdiction, my role, my determination?
Yeah.
Subject matter determination, Mr. Lenka, have you checked? Kona gala? Oh, adhir achi. Acha, theek hai. Take question. Eta ithir achi. Prayer hela ko, Mr. Lenka, can you check the list of the prayer, page 3?
The allegation is during paddy.
Minimum price ta kutre achi, ko subject matter achi. Division bench na single bench pratham
Single.
Again?
Single bench.
MSP achi more ye.
Supply department matter.
Eita is more achi essential commodities, OPDS, dita achi. But I think ଆପଣଙ୍କର procurement ଟା ହଉନି ଆପଣଙ୍କର ଏଥିରେ essential commodities ରେ procurement ହୁଏନି. Essential commodities for distribution.
This is
ଆପଣଙ୍କ distribution ନୁହଁ, ଆପଣ ଚାହୁଁଛନ୍ତି ବିକ୍ରି କରିବା ପାଇଁ. ଓଲଟା just the reverse.
so supply department matter.
Department ସେମିତି କଣ ଆସେ determination department the cases relating to supply department ସେମିତି କିଛି ନାହିଁ. ଆପଣଙ୍କର ଏଥିରେ ଥିବ regulated market committee ସେଥିରେ ଥିବ. ଆପଣଙ୍କ RMC purchase କରୁଥିବ ତ?
Not RMC.
ଆଉ କୋଉଠି କୋଉ ୟାର୍ଡରେ
That
ବିକୁଛନ୍ତି?
is PAX, Primary Agricultural Society, which collects these lands.
ନାଇଁ ଯୋଉଠି ଆପଣ ବିକୁଛନ୍ତି ସେଟା କୋଉ ଜାଗା?
ସେଟା society ମାନଙ୍କରେ ବିକ୍ରି ହଉଛି ସେ
ମୁଁ ସୋସାଇଟି ମୁଁ ପୁରାଟା କହିଲି ପ୍ରାଇମେରୀ ଏଗ୍ରିକଲଚର ସୋସାଇଟି.
Primary Agricultural Society.
ଧାନ ବିକ୍ରି ଏବଂ ଧାନ ଚାଉଳ ଡିଷ୍ଟ୍ରିବ୍ୟୁସନ ଅଲଗା ଜିନିଷ. ଆପଣ ଧାନ ବିକିବାକୁ ଚାହୁଁଛନ୍ତି?
ଧାନ ବିକ୍ରି କରିବାକୁ ଚାହୁଁଛି.
ମିଷ୍ଟର ଲେଙ୍କା ଚାଉଳ ଦଉଛନ୍ତି.
That is PDS, under PDS.
PDS ମୋର ଡିଟରମିନେସନ PDS ଅଛି. PDS is clear. ମୋର not assigned to କିଛି ତ ନାହିଁ. Not assigned to single bench କୋଉଟା? ଟିକେ ପାସ୍ ଓଭର କରିଦଉଛି. Can you wait? କେସ୍ ଅପେକ୍ଷା କରିପାରିବେ? So just wait for few minutes. Any difficulty if I sit little longer beyond because usually I rise at 1. Can we continue for ଆପଣ ଟିକେ ଏଟା ଦେଖି ଦିଅନ୍ତୁ. Next matter ଟା ନଉଛି.
May I suggest one thing, madam? He has filed a representation before the collector.
ମୋର ତ ଆଜ୍ଞା jurisdiction ନାହିଁ. Representation dispose କରିବା ପାଇଁ ବି ମୋର jurisdiction ନାହିଁ. To achieve a disposal ତାର ବି jurisdiction ନାହିଁ. ଆପଣ ଟିକେ ହେଲ୍ପ କରନ୍ତୁ. ଟିକେ ଦେଖି ଦିଅନ୍ତୁ କୋର୍ଟରେ ଆସିବ. Next. Mr. Mishra, kindly take your seat. So he will just go through and find out the determination.
Item 9.
I'm appearing for the husband and lordship with a very simple prayer, lordship. The proceedings is pending before the family court, Bhubaneswar.
Mr. Tribunal, most complex you have argued. Today's matter, most complex is your matter. Good. I mean, when thought-provoking things are always encouraging.
I will
so
also,
many aspects.
on the next date, I will be better prepared with the case.
No, it's not.
What is the provision? Because I wasn't aware about this aspect. I have not thought from this
That is
aspect.
what, once a student of law, I'm always a student of law.
That's the.
So while interacting with you, these things I realized that. So now the simplest of cases, what is the most simplest of cases?
Your lordship, the early disposal of the proceedings before the husband and wife, lordship, matrimonial proceeding is going on, lordship, from 2020.
I will allow if you say that that's the only case pending. Other litigants
Lordship.
cannot be discriminated.
Then
That order prioritizing your case is a clearly discriminatory order.
Then your lordship may pass it or I will take instruction whether
Mr.
any.
Cora's case, what about his cases? What about Mr. Mishra from Kendrapada? So prioritizing cases is a very discriminatory order and for no reason also.
Lordship.
And in the administrative side, we are saying that you dispose of cases, all cases.
It is pending
And-
from 21, your lordship. In a time.
2001. But the question is that you have to be assertive on your plea that this is the only case the court is taking up, no other case.
No, lordship. That
So
I cannot.
then how can I prioritize? You book the court.
In a time bound manner, lordship. I'm not praying for fixing a time period.
How does Mr. Cora's case?
Lordship, from 21.
Approaching a high court
Lordship.
cannot end up in discriminating others who are not before the parties before this court. What about other litigants?
Your lordship, but the
You
party
see,
that opposed this court, his rights are must be protected, your lordship.
Correct. But what about the matters pending prior to 2021?
Lordship.
That is what I'm asking you. There you are seeking that no matter is pending prior to 2021.
That is not the case, your lordship.
Then that is a disservice to the right to equality also.
Lordship, just in a time bound manner, your lordship. What I'm saying is, I'm
not saying other cases. If it is a general direction, he has to follow. Then you are seeking mandamus, not or 227.
Lordship.
Suppose there is a timeline.
Lordship.
The things have to be done in a timeline, CPC, CRPC, whatever. I'll give you an example. Family Courts Act. The court has deviated. Then you are seeking a direction at 227. What you are seeking otherwise a direction that let him expedite it and in a time-bound manner.
Lordship.
There it is for the court to decide. Or you have moved a petition for certain things, court has not passed the order.
Lordship.
There also definitely I have a power to interfere. But this is a case where you are seeking discrimination, prioritization of your case. at the cost of others.
Not at the cost of the others, Your Lordship.
No,
This
no.
is
Then I have to observe it. It is definitely at the cost of others. Judicial time has to be distributed.
equally, Your Lordship.
So
It has to be,
2020 matter, 2019 matter, that should be your case.
Your Lordship.
Though no earlier matter is pending, then still the court is not taking up of the matter.
No, the court is taking up. I
That-
will not make
And
that
it's a
allegation,
different, there are the decisions of Supreme Court on this,
Lordship.
that this cannot be done. Then everyone will come before the court and seeking a early disposal, and I will say that the disposal within 2 months. Then at least 100 cases, in a conservative estimate, there will be 100 of cases
Yes, Your Lordship.
prior to this. You never know, maybe 1,000.
Lordship.
Then what? It is not legally permissible. Somebody approaching to the court, getting an order, not possible.
Lordship, I'm not saying
You move the court. They will, or you have stated what is the stage of this case.
Your Lordship, I have annexed the order sheet, Your Lordship.
Now what has happened? Annexing is not important.
Your Lordship. It
So
is
how
for
much
the-
time it will take?
It is for
Like whether the evidence is complete.
evidence stage, Your Lordship. Evidence has just begun, Your Lordship.
Then how can I expedite?
Evidence has just
There are
begun.
so many factors, mister. If you visit the trial courts, you will realize what is happening.
Thank
To
you,
what
Your
extent the lawyers are cooperating or not.
Lordship.
Mr. Saurabh Tibrewal for the petitioner. The petitioner seeks direction to the learned court item 9 of College. Learned Judge Family Court 1, Bhubaneswar. Bhubaneswar is a severe problem, mister. Too much of pendants. It is in thousands. It has not cost a lakh, but it is in thousands. Tens of thousands. That correct. Direction to be issued to the Learned Judge Family Court, Bhubaneswar, to dispose of CP number 1126 of 2022 at an early date. The said application was filed by the petitioner herein, husband in the marriage under section 13 of the Hindu Marriage Act 1955, seeking resolution of the marriage with is steering her to get remarried or what?
No, Lordship. Off the record, Your Lordship, he is paying maintenance on a regular basis. So he's saying that get it over it, I'll pay the alimony and matter will be over, Your Lordship.
Seeking divorce is his business. Maintenance is court has to direct.
I'm
So it is his business only.
Lordship.
Visual marriage with the opposite party. Para. Having gone through the contents, having gone through the petition, in considered opinion of this court, a direction cannot be issued to expedite the matter by a court when other older matters in thousands are pending. On being asked, on being asked, the Learned Counsel for the petitioner submits that evidence has just begun. Here, Delany, petitioner evidence is opposite party.
Petitioner evidence.
The petitioner's evidence has just started before the Learned Trial Court. In considered view of this court, it would not be in the interest of justice to direct a particular case to be prioritized when several cases are pending, which are older and also at the same stage, or maybe at a stage which is advanced stage of litigation. However, it shall be open to the petitioner to approach the court for any appropriate order. This shall be considered in its own merit in accordance with law. The petition is disposed of accordingly. Mr. Lenka, residuary bill not assigned to any other bench?
And Honorable Justice H.C. Mehra, your Lordship will find the agricultural products, marketing, etc., assigned to Justice Honorable A.C. Mehra. Read picture relating to Orissa Agriculture Market Produce Markets Act.
Okay.
Then
See petition ne jota Mr. Misrain person jota korchon isbe koda challenge korchon dekhile?
एथिरे से कहते हैं जो प्रोक्योरमेंट डेट तक माने थिला अप टू 30th अगस्त
आई स्कैनिंग थिला
थिला सेटा को बिफोर 5 days before they have
प्रीमेच्योरली समाने
and also single bench matters not assigned to elsewhere, that is alerted to Honorable Justice B.P. Raut.
so this is
So both ways I am not more. Sir, this is not in my determination.
Let registry be.
नहीं मोर से but तांको help करे पे at least गोड़े को subject matter गोड़े hint देला हबो.
Mr. Behra is there.
हाँ, Honorable Justice A.C. Behra's court is there. Serial number 16. Read petition relating to Orissa agricultural produce market.
The petitioner has approached this court seeking a direction. And the nature of prayer is in PIL. Can I upon the individual upon the eye scanning function?
Yeah.
Pertaining to sell his agricultural produce at minimum support price. Stop. Apparently, the said subject matter is not assigned, is not in the determination of this bench. The registry shall do the needful for listing of the matter before the assigned bench. Liberty to mention. Or either mention Coram to registry. Yeah. The rest of the matters after recess.
Interim order is there for the petitioner.
No, in fact, it is a interim order is till next date or what is the
Till next date.
next date is there. So we'll mark. You are Mr.
J.
Samantre.
Jagdeep Sahoo.
So J. Sahoo.
Lordship.
Okay. Okay. Otherwise, simple adjournment will doesn't vary any interim order. Judicial order, unless varied, as subsists.
Lordships.
Yes.
Okay.
Pardon to mention your lordship, item 33. Similarly, it was added by the opposite party. And
Your name, sir?
Haraprasad Panda, I am for the petitioner.
You are Haraprasad Panda. Yourself. IOC, interim order to continue.
My lord.
Again, I mean, they don't say anything. Even sorry. Yes.
I don't 21 my
But wherever it is till the next date of hearing, you need not worry because
My lord.
I don't 21 my lord.
yes,
I am filed Mukadma my lord on 15th January my lord. My name is not restricted.
what's your name, sir?
Ajay Kumar Das, sir. As per OP number 2.
Along with Mr. G. N. Misra.
No my lord. She was for the OP number 3.
So you have to wait, you have to pass a judicial order on that. Ajay Kumar Das, your name should be recorded, you want.
My lord, I am filed Mokadama on 13th January. Fresh Mokadama file.
আগুর কি appear করছিলে?
Sir, I could be connect, sir.
Who passed away?
My lord.
Okay.
I am for the
Okay. OP3.
I am for the OP number 2. OP number 2. College, IGIT.
Okay. ঠিক আছে।
Item number 15. Orders.
Again.
I have filed for appropriate orders. I say I am the wife.
That is for non-payment of maintenance. It was wrongly filed and she wants to.
That has already we received the money from the husband. So that IA is infructuous.
File memo.
Yes.
Memo ଦିଅନ୍ତୁ।
Yes.
ଦେଖି ଦିଅନ୍ତୁ ଗୋଟେ ଧାଡି ଲେଖନ୍ତୁ।
ଆଜ୍ଞା ଲେଖିଛି।
I have prayed for adjournment and interim order to continue.
ଆପଣ ଯୋଉ IA ଟା ଆପଣ ଚାହୁଁଛନ୍ତି not pressed, reason ଲେଖିଦେବେ।
ଆଜ୍ଞା ଲେଖିଛି। In this case, my counter was also filed. He has not filed the rejoinder. Let it come.
ସେ time ନେଲେ ପରା।
And in the morning I have mentioned 2 weeks time to file rejoinder.
Just fix up a date, sir.
16/2 ପରା week commencing 16/2 କହିଛନ୍ତି।
Item 16.
16.
Madam. This matter notice has sent, it has been written back on server. In between some development has been made.
You are there for the petition?
I am for the petitioner, madam, for enhancement of the maintenance.
So the opposite party is appearing in some matter?
Opposite party, no, my lord.
Opposite party, if he's appearing in before the lower court, notice can be served there?
No, my lord, what happened during the pendency of the restitution of conjugal life file? In between what happened, he has filed a petition for divorce. So what I beg to stay, subject to acceptance of my lord, that let this maintenance, which I speaks for enhancement, because we could not able to file any substantial document with regard to the income. Now I have filed a petition to showing that income tax he is earning 4 to 7 lakhs. All these things can be a divorce petition. We can.
How can I direct in a RPFM divorce?
My lord, then notice may be
the lack of jurisdiction.
My lord, then notice.
Complete lack of jurisdiction.
My lord will.
So again, coming back to what I said, could you follow what I said?
Sir, my lord, lower court to advocate maybe serve the notice.
The person also, you have to file a memo indicating where she appears. Based on that memo, this court will pass a order. But this court cannot control a CP as far as section 24. We have filed a section 24 in 13 was filed.
25, sir.
ବର୍ତ୍ତମାନ ଯୋଉ 13 ଫାଇଲ ହେଇଛି
13 ସେ ଫାଇଲ ହଜବେଣ୍ଡ ଫାଇଲ କରିଛି
ସେଥିରେ ଆପଣ 24 ଫାଇଲ କରିଛନ୍ତି କି
ଆମେ ଫାଇଲ କରୁଛୁ
ସେଟା ତ ପଚାରୁଛି so that cannot be regulated by in the 125 proceeding 125 payment would be a factor that would be factored into that amount but this court should not control that is my understanding of law obviously
I got him.
No, you need not. It's always a deliberation. Why should you accept actually? If then there will be no growth. So, one thing you can do, you should actually. My understanding is that whatever happens in section 24, only the amount should be deducted. How much 125 has been award has been made?
5,000.
5,000. Suppose the 124 in 24, the court decides 8,000. Then 3,000 more. That much. That should be the approach. That is because if you complicate it further, then it becomes a never-ending problem.
Then I would like to suggest let it go fresh notice to them.
Fresh notice, better you ensure give the number the court where it is appearing.
That
through the court. Yes. Now you file that memo. I'll just take it up now.
I will file. Attaching with the petition filed before them.
No difficulties. If you mention the number, that is enough.
I'll file.
Call କରନ୍ତୁ
Item 10
ଗୋଟେ କାଗଜ ଦେଇ ଦିଅନ୍ତୁ ସାର୍ 10 के नांदी
Item 10 for the opposite parties I am there. Already there is no cause of action left to be adjudicated, my lord.
File a memo.
Yes.
ଆପଣ ଆଉ ଗୋଟେ ବି କାଗଜ ଦିଅନ୍ତୁ କାହିଁ କହୁଛନ୍ତି cause of action doesn't survive?
My lord, because as per instructions received from my client, he says that CS number 71/2014 has been already disposed of.
So can you give the date of disposal?
Oh, my lord, I'll.
Okay, you find that memo.
Yes.
Whatever instruction you have, you bring it on record. I'm passing it over. Then 10 pass over.
11,
Mr. Lalatendu Bhuya for the petitioner. The learned counsel for the petitioner seeks and has accommodation to remove the defects within 10 days. Stop. Accordingly, the matter shall be listed in the week commencing 2/2/2026.
item 12,
Or withdraw. Learned counsel for the petitioner. तो नाटा लिखिले कि मुझे नाटा लिखी पानी Mr. S.K. Mahanti, learned counsel, for the petitioner, opposite party blank. Learned counsel for the petitioner files memo of date which states thus, quote कर देवे है ना. Accordingly, accordingly the petition stands disposed of. Copy of this order shall be forwarded by the registry to the Court of the Learned Judge, Family Court, Berhampur, to be tagged to the records of the criminal proceeding number 280/2018, disposed of on 24/2/2022. Yeah. तो मेमो टा लिखले तापर लिखिबे मेमो which states thus तापर लिखे तो memo is taken on record. Scanned copy be updated.
item 13,
थर्टीन रे देना थी तो सिंपली डेट कर देछे ना कौन करछे
विद्यानी दिलेश
कौन पहले स्टार्ट 13 रे पीके मलिक मेंशन करले एडजर्नमेंट पे
खाली आपचन विद्यानी
तले आपण कर दियंतु छाड़ दियंतु
ओई कन्वेंशन लॉ
ठीक अछि 13 रे किछि लिखंतु से पोस्टिंग कर देले 14
14,
Mr. D. Sahoo for the petitioner. Office note put up by the registry indicates that Mr. Gurudatta Kara for the petitioner. Office note put up by the registry indicates that notice issued to the sole opposite party has been returned undelivered with postal remark, quote, no such addressee. Hence return to sender. Quote ends. Basically, it is stop. It is submitted by the Learned Counsel for the petitioner that say memo ta kode gala.
Memo to.
Or petition copy ta darkar nahi. I don't require a memo ta. In case number so and so, pending before so and so, the opposite party is appearing regularly, and direction may be issued for service of notice to the said court. Stop. Accordingly, it is directed that requisites shall be filed for issuance of notice through the said through the court of Learned Amko.
CP number 83 of 2025 pending before the family court.
CP number 83 of 2025 pending before the Learned Judge, Family Court, Bhadrak. The unutilized copy due to non-service of notice through the post shall be utilized. Then steps be taken within 3 working days.
Minor.
the steps be taken for issuance of notice to registry, which shall be forwarded to the allotted court in season of the matter within 3 working days. तापर लिखिए, the allotted court shall through its office direct service of notice issued by this court on the opposite party in person as well as our allotted counsel. His
not counsel.
As well as his learned counsel. The service return shall be forwarded to this to the registry of this court to be tagged to the file. Just in the week commencing, 4 सप्ताह time दे दियो. Date जान से देखिए.
Next date time.
इतने next date है important. So specific direction होगा. रखिए. Week commencing 23/2/2026. तो memo filed by the ऊपर लिख ले submits there. Appearing so and so तापर लिखिए. Case number luckily indicating the same, the memo is filed which is taken on record.
Obliged.
Scan copy be updated. You are appearing. Mr. Gujarat Seth for the petitioner. Opposite party blank. Anandu sir. The office note put up by the registry indicate that the admission notice issued to sole opposite party has been returned undelivered with postal endorsement. Addressee cannot be located, hence returned to sender. Hotels. It is submitted by learned counsel Mr. Rabinaran Mohanty.
Yes, sir.
Mr. Rabinaran Mohanty, that he has instructions to appear and he shall file a wakalatnama in the registry today along with his learned associates.
Yes.
The wakalatnama shall be taken on record, scanned copy be updated. The learned counsel shall also have the liberty to receive the copy of the petition which has been returned undelivered. Receive. Receive from the registry of this court, then copy of the writ petition which has been returned on along with notice, copy of the writ petition along with notice which has been returned unserved. Registry नहीं जानते हो?
Prayer lordship to counter and I will file you within a week, lordship. And
prayer न करें बाबा.
And matter will take.
वो जो पावर नहीं जो आपको ना करें फाइल करें नहीं सजना कोई भी.
Lordship, matter will take.
उनके सिरी वाला कहीं की सिरा का लेखा.
So matter will take.
You should not be casual.
Yes, lordship. Matter will take up by short adjournment, lordship. And
entry order ही चिना कौन? Entry order passed earlier shall continue till the next date. List in the week commencing 16/2/2026.
18.
Mr. S.C. Misra on behalf of R.N. Prushti for the petitioner. Miss A. Misra on behalf of Manish Dhir for the opposite party. Learned counsel for the petitioner seeks for adjournment. Learned counsel for the opposite party submits that the interim order is continuing and there has been the learned counsel for the opposite party opposes the prayer for adjournment and submits that on several earlier occasions adjournment was granted. Stop. Para. List in the week commencing 2/2/2025. 26. Code 25 लिखिए. 26. Yes.
Item 19.
Yes, Mr. Swai.
There is a delay of about 27 days, Lord. But the office wrongly pointed out.
What is the petition?
I am challenging the order passed by the learned family judge, Jagashimpur, in CRP number.
Directing what?
My lord, filed under section 125 application by the wife.
What is the direction you are challenging?
I beg pardon.
What is the direction you are challenging?
The husband to appear but did not take step thereafter. So the CRP proceeding, the order passed ex parte, my lord. In absence of the husband.
Yes. You are said ex parte.
Yes, my lord.
So it is illegal.
Yes, my lord. The
Ex parte order cannot be legal. Which provision?
but I have not.
Ex parte provision is there in CPC.
Yes.
So delay will not be condoned. Deposit the amount, then it will be condoned or it will be dismissed.
I have deposited 15,000. Earlier, I have filed an application under.
The amount in default. Total amount in default.
What happened in this case? The wife earlier married.
Sir, question is, what is the amount you are in default? And which court has stayed the order? Or you yourself have stayed the order?
No, my lord.
There is no provision that the parties, if they want, they will stay the order.
The matter has not been stayed.
So then you pay. Or it is
I have already. I have in earlier. I have filed another application in the interpretation.
The problem is that if you say too many things, I don't have capacity to understand. I have a simple query. What is the net amount of default?
Total amount I have not paid. Only I have paid only 15.
So there is no
There is no scope to appear.
There is no totally no merit.
Due to communication gap between the advocate and the parties.
So he is communicating with you.
Yes, ma'am.
So either he pays or the matter gets dismissed.
It's because he's not entitled to get at a maintenance because
that is
earlier he was married.
That is a merit. You look at 125, you will realize that.
But that opportunity I have to.
You read 125, then you will understand the opportunity. Is there the provision in 125?
Yes, I read.
What is the language? Kindly educate me. Why you read alone, sir? I need to be educated also. That 125, what the court will do, entitlement will decide.
So for income part is concerned, Lord. Your lordship kind of glanced down.
Sir, this is not the 125 petition. This is appeal. So confine your pleadings to the appeal. What you argued before the court, that you confine to them.
But your lordship, I may permitted to file my show cause at least.
Who prevented you from filing your show?
But the final order.
Don't guide the court, misguide the court to pass wrong orders. Because I have to then record that so and so was prevented from filing show cause. So it's a that wrong order I will not pass postulated by you.
In absence of me, the order
it has to be court is not to give you.
I have not.
Court is not giving inviting you. Court issued you summons. You did not bother to.
I admitted that. I have
submitting a summon does not exonerate you from non-compliance. From compliance, sorry.
Due to non-communication gap between the advocate.
Sir, which provision? Due to communication gap, court has to show indulgence. You have to always make a legally known submission. So which communication gap, when it was brought to the notice of the court, whether the court has a power under CPC or CRPC that whenever there is a communication gap between the lawyer and the person, then it will not pass orders. It will try to bridge the communication or abridge the communication. Unless, sir, I pass a legally nuanced order, my order should make some sense. Can I pass an order? There is communication gap. So the CRPC ban prohibits such order to be passed whenever there is a communication gap between the lawyer and the client.
But the wife suppression the material fact, but she marriage earlier. That is the whole difference.
Sir, whatever, sir, that is not part of the record.
That
you have formed your opinion regarding the wife of your client. Court cannot. Personal opinions are always bad. For court, it cannot happen. It is illegal. And for a lawyer also, you don't form opinion. You go by the record. Whenever your client is telling, you look at the record and advise.
Since I have not filed the SOCAJ and I also again.
So kindly, I've been asking you what prevented you and when did it happen? And when the court is under the duty to wait for you.
This is my mistake here.
No, it's not a question of somebody's mistake. It's a legal process.
Due to laches of the advocate, the client should not suffer.
But there is nothing. I kindly find out where the court has said that the laches of the advocate.
And that the court should not.
Don't make submissions in air.
Your Lordship
Do you think that because I arrived straight away, I will not prepare myself? I landed up in court straight away. So that doesn't mean that I am not prepared.
In paragraph 3, Lord, subsequently he did not file so much. Accordingly, he was precluded to file so much. By dated.
You look at the order. Don't make submissions in air. Which part of the order you are basing your submissions? Because you are making submissions in air.
It is
as if because I
paragraph 3, it has
been to reach here to 2000 kilometers, you will make submissions in air. I have to substantiate my order. I cannot take this plea in my order, indicate that communication gap. He was prevented from filing his written statement. Court did not wait for his written statement, which is the provision in 125 CRPC. You have yet to read 125 CRPC. I have been requesting you.
There is in 135 CRPC, there is no such languages there.
Then why you are arguing? You are arguing a 125 CRPC petition in appeal.
Yeah, my only pledge since the order passed in absence of
you cannot take advantage of your own wrong.
That is,
I cannot give you accolades for not responding to court's notice. Please appreciate.
I have appeared.
When you do something wrong, you cannot take advantage of that. Somebody doesn't bother to appear in a court. The appellate court will give imprimatur to that. That since you did not appear, you should now give him a chance.
Sir, I appeared. Subsequently.
So it's up to you. When did you approach the court for accepting your written statement?
I have never filed the written statement.
Please, sir. So if I record that, then your case goes to 0.
Sir, I have never.
Be serious about your client also.
Sir, it's
on the first of it, you are making a wrong submission. When did you file before the court, approach the court that you now I am appearing and accept my written statement?
I have never filed.
Then
it is
then how can I now impute that to the court that you accept he's a special person? I like him. You accept his written statement.
In the meantime,
you have to show some provision in law to appellate court to act like this. I cannot give imprimatur to your wrongdoing.
Recommended one date. I will.
Nothing is there. Shortest possible date you decide for dismissal. These questions court should not ask you. You should ask to your client because these are the part of client interviewing. Client interviewing is important part of advocacy so that you stand firmly whatever you are arguing. Whatever you are arguing is beyond record, not in consonance with law. And the worst submission is that you are saying that because you did not appear, this appellate court should allow you to take advantage of that.
I am not.
Did you approach the court saying you are filing any petition?
No.
Then?
That is objection you'll also dispose.
No, why should I observe that? Why should I observe that? Am I doing a charity business or whatever? Whoever comes, I will start throwing things. Sir, it is court. I am duty bound to look at both the cases, both the parties. I have a very liking for you and for your client, maybe for your client. I cannot do that. Look at paragraph 3 and 4.
Yes, sir. In the instance case, the opposite party had entered his appearance through his advocate.
Let's put the microphone. Microphone देखो. Mic. जब switch on कर देने. Microphone ना switch on. See कर दे. On अच्छी. Position तो on.
In the instance case, the opposite party has entered his appearance through his advocate, but subsequently he did not file his sokaj. Accordingly, he was precluded to file sokaj by the order dated 9/4/2024.
Have you challenged that? 9/4/24 order?
I have not challenged.
Then, sir, don't make the court's order so vulnerable. You are also officer of the court. If you guide me in a wrong direction, I will be guided. Then kindly read 4.
In course of hearing from the side of the petitioner, 2 witnesses are examined, including the petitioner as PW1 and her father as PW2, and stated subsequently substantially corroborated the affirmation made in the petition. Neither the opposite party remained present to cross-examine the petitioner, nor he adduced any evidence from his side in course of hearing of the case.
Under which provision this can be the court will not take note of your CA? What is the provision? If you choose not to respond to court, appellate court will come to your rescue. Which provision?
File ordinance, file ordinance, set aside expedited decree.
What is that provision?
Ordinance rule 30.
Is it applicable to CRPC?
No.
Then? Because you have not read 125, most likely, or you are now not responding to my, just like your client did not respond, you are not responding to court's queries. Look at 125 language.
Yes, no.
Read about. On production of a magistrate file.
Sir.
125 D para पढ़ो.
Provided further that the magistrate may
provided टा कम provide पढ़ो तुम section टा पढ़ो तू
the
D पर जोड़ा लिखा है ये magistrate
his father and or mother unable to maintain herself or herself, a magistrate of the first class may, upon proof of such neglect or refusal.
So that is enough. Stop there. आप किसी section आप किसी नहीं.
Neglect and refusal.
अपन trial करे बोले कुछ भाव चुन trial हो सकती बोली. Upon proof of such neglect or refusal is enough. Then look read 3.
Sir. If any person so order fail without sufficient cause.
Fails.
If any person so order fails without sufficient cause to comply with the order, comma, any such magistrate may, comma, for every breach of order issue a warrant of levying the warrant for levying the amount due in the manner provided for levying fines, and may sentence such person for whole or any part of each month, allowing for the maintenance,
allowance, not allowing,
or interim maintenance and expenses of proceeding as the case may be, remaining unpaid after the execution of warrant, or to imprisonment for a term which may extend to 1 month or until payment if sooner made.
So, where does the appellate court comes in? So, shortest possible date you decide when you can argue the matter, or today, finally you argue, or you deposit the amount, whatever is due.
Your Lordship, next week date may fix. I will.
No, your choice. Date is yours.
28.
Okay?
28.
28.
28.
28. Hey, we commencing do you? The Lord counsel for the petitioner was had at length. The petitioner husband in the marriage approached this court, challenging the order dated 29/8/2025, challenging the judgment dated 29/8/2025, passed by the Lord Judge, Family Court, Jagatsinghpur, in CRL. Proceeding number 136 of 2023. The appeal has been filed after a delay of reported delay of 392 days.
There is delay of 27 days. Office wrongly pointed out. Because, Lord, the judgment judgment
ଷ୍ଟାମ୍ପ ରିପୋର୍ଟ ଦେଖିଛନ୍ତି ନା ଅନ୍ଦାଜ କରି କହୁଛନ୍ତି? ଦେଖନ୍ତୁ ସେଠି ଅନ୍ଦାଜ କରିବାଟା ଗୋଟେ କେବେ ବି ଚାନ୍ସ ନେବେନି। ଓକିଲାତିରେ ନେଭର ମେକ୍ ଅନ୍ଦାଜ। ଟିକେ ପଢନ୍ତୁ ଟିକେ ଆଜ୍ଞା, ଦେଖୁ ରିପୋର୍ଟଟା ଦେଖିବେ ନା ଆଉ। ତାପରେ କୋର୍ଟରେ କଣ ସବୁବେଳେ ଆପଣଙ୍କର ସ୍ପିନ୍ ବୋଲିଂ ହବ? କେତେବେଳେ ଏଣ୍ଡ୍ରିକ୍ ନରିଆ ଭଳିଆ ନା 155 ସ୍ପିଡରେ ଯିବ ଆପଣ ବିଫୋର ୟୁ ରିଆକ୍ଟ। ମତେ ତ 80 କିଲୋମିଟର ଦେଖାଯାଉନଥିଲା।
392 days.
ତା ପୂର୍ବଟା ପଢିବ, ସେଇଟା କଣ ଆପଣ ପଢିବା କଥା? ଆଜ ଏ ଲୟର ୟୁ ହାଭ୍ ଟୁ ସି ଡେଟ୍ ଅଫ ଭ୍ୟାଲିଡ ପ୍ରେଜେଣ୍ଟେସନ।
90 days.
29/8/25 ହଉଛି ଡେଟ୍, ଭ୍ୟାଲିଡ ହଉଛି 24/12/25। କଣ ଲେଖିଲେ? 482 days. 392 days. It is submitted by the learned counsel for the petitioner that apparently there is error in the stamp reporting. The date of judgment being 29/8/2025 and the date of valid presentation being 24/12/2025. So accordingly, the matter shall be placed before the learned registrar judicial for referring the matter for stamp reporting to be done again. Regarding merits of the case, it is admitted by the petitioner in the present petition that he, though appeared before the learned trial court, did not further participate in the proceeding. The learned trial court has considered materials on record in detail. As should be evident from the relevant paragraphs. Relevant paragraphs, that is paragraphs 3, 4, 6, 9. Scan करी reproduce ने कितनी करी?
11.
9 and 11. 9, 11 and 12. ଯଦି page wise scanning ର difficulty ହବ, ପୁରାଟା କରିଦେଲେ ବି ଚଳିବ, ଯୋଉଠି difficulty ହବ। The learned trial court, after considering the merits of the claim, instead of the claimed amount of rupees 15,000, has awarded rupees 5,000 per month from the date of application. Prima facie, no case is made out for interference with the said order passed by the learned court. However, being persuaded by the learned counsel for the petitioner, the matter shall be listed in the week commencing 2nd February 2026. ଆପଣଙ୍କର ଆଶା କଣ ଅଛି? ସେ କମ୍ପ୍ଲାଏ କରିବେ ନା ଏମିତି ଚାଲିବ କେସ୍ ପିଙ୍ଗ ପଙ୍ଗ?
ସେଟା କଣ କ୍ଲାଏଣ୍ଟ ଟୁ
ଏପଟେ ଆପଣଙ୍କର ପୁରା କମ୍ୟୁନିକେସନ ହେଇଗଲାଣି। ଆପଣ ସେତେବେଳେ ସିନା ଲ୍ୟାକ୍ ଅଫ କମ୍ୟୁନିକେସନ ଥିଲା, ଭଲ କମ୍ୟୁନିକେସନ ଅଛି। ଆପଣ ଟିକେ କମ୍ୟୁନିକେଟ କରନ୍ତୁ କୋର୍ଟର ଭ୍ୟୁ। ଟିକେ 3ଟା ଟିକେ ପଢାନ୍ତୁ। 3ରେ କଣ ଅଛି?
ସେଟା ସଫିସିଏଣ୍ଟ କଜ ଦେଖେଇ ସେ ସେଠି ହିଁ
ସଫିସିଏଣ୍ଟ କଜ ଦେଖିବ।
ସଫିସିଏଣ୍ଟ 3ରେ ସେ ସେଠି ବି
ଆରେଷ୍ଟ ହେଇକି ମାସେ ଜେଲରେ ରହିବେ। 3ଟା ଦେଖେଇବେ ନା ଆଉ, ନହେଲେ ଆପଣ କଣ ସେ ଆପଣଙ୍କୁ କେମିତି ଆଉ ୟୁ ୱିଲ୍ ନଟ୍ କେୟାର ଫର ୟୁ। କଣ ଲେଖିଲେ? କମ୍ୟୁନିକେସନ 2nd February ଆସୁ ଦେଖନ୍ତୁ କଣ ଅଛି। The registry shall do the needful for stamp reporting to be done again. Yes, next.
Item 20.
I may be pardoned, my lord. I am for the opposite party number 3 and 4. 4 is already died, and she is the mother of opposite party number 3. थ्री अपोजिट पार्टी थ्री रो मिसेस देह खराब होता कौन से मेडिकल पड़ता कुछ इंस्ट्रक्शन हेलो काइंडली 3 weeks टाइम में काइंड बी ग्रांटेड फॉर टेक इंस्ट्रक्शन फ्रॉम द क्लाइंट.
Mr. Behuria, you are Mr.
Nityabrata Behuria, my lord.
Nityabrata. Mr. Nityabrata Behuria, on behalf of Nityanand N. Behuria for the petitioner, Miss MS. S. Rautre.
Naik.
I'm sorry, S. Naik. S. Naik. S. Naik for the opposite party. Number?
3.
Number 3. 4 पे आपण अपेयर करू नांती
4 नंबर एक्सपायर करी गले ताको
नहीं सी सब्स्टिट्यूट हे गले ता परे लीगल हेयर्स को पे एलआरएस को पे
नहीं
तो नोटिस न पड़ियो
नहीं हमको कहि ना थी
नोटिस जाइतला तांग पाखु returned with sufficient my lords. Thereafter also they are not appearing in this case.
then what best can be done आपण प्रोप्राइटर को पे कहउचंती प्रोप्राइटर को फोन को भीतर रिलेशन कोन धीरेश्वर और दिलेश्वर आक भीतर कोन रिलेशन धनेश्वरी
Dhaneshwari is the mother of opposite party number 3.
धीरेश्वर
तो सेट पे मतलब मु ठीक बुझी छी आपण जदी ताको पे अपेयर करबेनी फिर तो केस सरीबनी चलला ता पर
तो सेट में कहली 3 weeks टाइम दियन तो ताको इंस्ट्रक्शन
नहीं ठीक अछि बट माने आई सीक योर इंस्ट्रक्शन जे आपण वेदर यू आर माने आई मीन you talk obtain instruction because you have heard your young colleague he says that after notice being sufficient they are not appearing but your relationship is that Khireshwar Dhaneshwari is mother of Khireshwar
yes
तो केमती होता है कौन लेकिन appearance के lecture में it is submitted by the Learned Council Miss Naik that she has to obtain instruction from the OP number 3 and some further time may be granted. It is submitted by the Learned Council for the petitioner that after substitution of the OP number 4, since he unfortunately passed away by the legal heirs who have been brought on record, notices were issued. Stop. Though the notices are sufficient, they have chosen not to appear. The OP number 4, since deceased, is mother of the OP number 3. Stop. Accordingly, the Learned Council for the OP number 3 shall also obtain instructions in the matter from the substituted legal heirs of the OP number 4. I am not compelling you because the court cannot. But if you can help the cause, then something could happen in the matter. Otherwise, sufficiency of notice, this matter will have it. Yes, next. List in the week commencing 4 सप्ताह पर 3 सप्ताह motions. Week commencing 23 20
May I pray for further postponement because in that week I have some personal difficulty.
No issues. पहले मार्च को जीवो.
March first.
Sorry वाला. February.
March first. First week.
In the week commencing 9th of March.
Well, it's great.
3-4 छुट्टी अछि.
Well, grateful.
Yes, next.
41.
Mr. LP Dwivedi for the Korea appear kuchuni State Council.
My lord, ma'am.
Lekhi Sahoo, additional standing council. State. Mr. LP Dwivedi for the petitioner. It is quiz. Yeah, quiz list. LP Dwivedi for the petitioner. Mr. GN Misra for OP number 3. Mr. P.K. Sahoo, Additional Standing Counsel for OP1. It is submitted by Mr. A.K. Das, Learned Counsel, that after the Learned Counsel, who had earlier entered appearance on behalf of OP number 2, unfortunately passed away. He has filed Wakalatnama on 13/1/2026. Registry cell. Locate the Wakalatnama. Registry cell locate the Wakalatnama. Tag the send to the brief. Scan copy be updated. Name of Mr. B.K. Nayak. Name of the Learned Counsel who were appearing earlier for OP number 2 shall be deleted from the cause list as well as the case brief. Name of Mr. A.K. Das, Learned Counsel and associates shall be indicated in the cause list as well as the case brief appearing for OP number 2. List in the week commencing as paid for by the Learned Counsel for the petitioner. List in the week commencing 16/2/2026. Yes, next.
22.
Mr. Ramdas Achari. It is on simple adjournment, brother. ठीक है 22 ଆପଣ posting କରିଦେବେ. Yes.
23.
Mr. C.K. Nayak for the petitioner.
May I please, Your Lordships? The dispute relates to the promotion of the petitioner from assistant section officer to section officer.
Mr. This is a single bench matter writ petition.
Yes.
The last occasion it was amended. Amendment of the cost title was allowed. What I find, the state in school and mass should have been amended. That has not been done, but the earlier order says that
By virtue of court order, it was amended. Only I have to mention in the court paper. Court paper, I have to.
Court order file. Court.
Last order.
Last order.
Mr.
Order date 19/11/25.
Dispute is not there.
P.K. Sahoo, Additional Standing Counsel for opposite parties 1, 2 and 3. Director Higher Secondary Education.
Aଜ୍ଞା.
Correction ହେଇଛି
State and a copy of the amended cost title.
କିଛି amended ନୁହେଁ ସେ ସବୁ counter file ସବୁ.
No, sir. ସେଟା ହବନି. ଆପଣ ବୁଝିପାର kindly listen. What he is saying, unless he issues a letter to the other newly added OP, they will not respond.
That is difficult.
So he has to take notice that.
No, let's see what I am submitting.
This issue company.
No, what I am submitting.
Your point is well taken, sir. Are we differing with you?
No.
But suppose for pendency of the matter since 2020, the amendment is allowed in 2026 ରେ allow ହେଇଛି.
କୋର୍ଟ କହିଲେ ଲେଖିଦେବେ ତାଙ୍କୁ କପି ଦେଇଦେଲି ସବୁ ତାଙ୍କ ଲାଗି କପି ଦେଇଦେଲି କୋର୍ଟ
ଆପଣ ତ ଶୁଣିବେନି ଆପଣ ତାଙ୍କ ଲାଗି ଦେଲେ ସିଏ ଆପଣଙ୍କ ଲାଗି କେସ୍ କରୁଛନ୍ତି ବଟ୍ वी आर नॉट देयर ଯେ ଆପଣ ଯାହାକୁ 4 ଆଡ୍ କଲେ ସେ ତାଙ୍କୁ ନୋଟିସ୍ ନବାକୁ ପଡିବ ସେ ତାଙ୍କର ଚିଠି କରିବେ ସେଟା ଏଥିରେ କଣ ମୁଁ ସାର୍ କନଭର୍ଜିଂ ନାଇଁ ଆପଣଙ୍କ କହିଲି ହେଇଛି ବୋଲି ୟୁ ଡୋଣ୍ଟ ଇଟ୍ ଇଜ देयर ऑलरेडी ତାଙ୍କ ପେଜ ରେ ଆପଣଙ୍କ ଟିକେ କରେକ୍ସନ କରି ଦିଅନ୍ତୁ ଦେଖିକି ନହେଲେ ମିଷ୍ଟର ସାହୁ व्हाट यू डू लुक एट दिस पेपरलेस
Yes, sir. I was requesting my friend to one page copy. He could have.
Oh, it's cost title.
Cost title खाली मागुची मु
cost title court cost title
and state
सेटा सेतु प्रिंट करी होनी आपण कहि परिबे ते प्रिंट हे परिबन
तापर हायर एजुकेशन को डिलीट करिया कथा से करि नांदे तो ऑर्डर रे रिफ्लेक्ट हेनी खाली डायरेक्टर स्कूल मास
डिलीशन ठीक अछि आपण
वन टा सर देखो
नेसेसरी पार्टी को ऐड कर दियंतु हां नहीं बर्तन से कोथरे थिले की ସେ କୋଉଠି କାମ କରୁଥିଲେ?
ଯେ ସେ ଫାଷ୍ଟ ଥିଲେ ଡାଇରେକ୍ଟର ହାୟର ଏଜୁକେସନ।
ଠିକ ଅଛି, ବର୍ତ୍ତମାନ ସେ କୋଉ
ସ୍କୁଲ ଆଣ୍ଡ ମାସ୍, yes.
ସେ ସ୍କୁଲ ଆଣ୍ଡ ମାସ୍ ହେଇଯାଇଛି ତାଙ୍କ
obviously ସେ ତାପରେ ହାୟର ସେକେଣ୍ଡାରୀ ରେ ଥିଲେ।
ହଁ
so obviously ସ୍କୁଲ ଆଣ୍ଡ ମାସ୍।
ହଁ ନା 2019 ରେ ଯୋଉ ରିଟ୍ ପିଟିସନ ଟା ଥିଲା ଆମର, ସେଟାରେ ଆମର ହାୟର ସେକେଣ୍ଡାରୀ କରିଛୁ, ଏଥିରେ ବି ହାୟର ସେକେଣ୍ଡାରୀ କରିଛୁ।
ହାୟର ସେକେଣ୍ଡାରୀ ଆଉ ନାହିଁ ସେଟା,
ସେଟା ସ୍କୁଲ ଆଣ୍ଡ ମାସ୍ ହେଇଗଲା। ତେଣୁ
ସେ କିନ୍ତୁ ତାମାନେ 1 2 ସମସ୍ତଙ୍କୁ ଚେଞ୍ଜ କରିଦିଅ
କରିବା କଥା, ଖାଲି 2 ଟା କରୁଛନ୍ତି।
ପୁରା ଆମେଣ୍ଡେଡ ଫାଇଲ ତ କଟାକଟି ହେଲାଣି ପୁରା। ଆପଣ ଟିକେ ଦେଖନ୍ତୁ ସେଇଥିରେ। Let's say just kindly look at paperless. Read application टा से कर दो relax.
It's something. सुना।
First page से देखो।
आगे।
The coordinate bench by order dated to 19/11/2025 had directed that on oral prayer of the petitioner, Lord Counsel for the petitioner had directed Director Higher Secondary Education Orissa to be made a party in the writ application as OP number 4. The said implement has been carried out by carrying out has been carried out by the Lord Counsel for the petitioner. It is also seen that the opposite party number 1, 2 have been added as party, being secretary to the government and Department of Higher Education. OP number 2 being the Director of Higher Education, whereas the petitioner's employment being in the higher secondary college or school.
Yeah, school.
Higher secondary school. ସେଟା କେବେଠୁ ହେଲାଣି ସ୍କୁଲ ଆଣ୍ଡ ମାସ୍? 3-4 ବର୍ଷ ହେଇଗଲାଣି ତ।
20 ମସିହା 2020
with effect from 2019
ପରେ 20
with effect from 2019 the department the administrative department of the institution where the petitioner was working is the Department of School and Mass Education.
এটা 29/20 29/20 ରେ এটা ট্রান্সফার হয়েছে। there is a resolution in 29/12/2020 for transfer of the common cadre section to the
ନା ସେଟା ମୁଁ କହୁନି, administrative department କଥା ମୁଁ ପଚାରୁଛି।
ହଁ ସେଟା
19 ନା ସେଇଟା ତାପରେ ଡିପାର୍ଟମେଣ୍ଟ ଟା କେବଳ administrative department ବଦଳି ଯାଇଛି। It is submitted by the Lord Counsel for the petitioner that though the petition was filed in 2020, it is submitted by the Lord Counsel for the it is submitted by the Lord Counsel for the petitioner that he shall carry out the necessary corrections and file amended cost title, bringing in the Secretary Department of School and Mass Education, or adding, bringing in / adding the Secretary School and Mass Education, Director School and Mass Education, as well as Director Higher Education Cottaging. Director Secondary Education Higher Secondary. Secretary
School and Mass.
Bringing on record Secretary School and Mass Education Department.
The other two may be deleted.
ଆଜ୍ଞା ମୁଁ ଖାଲି ଟିକେ 2019 ମସିହାର ରିଟ୍ ପିଟିସନ ଟା ଦେଖନ୍ତୁ, ଯେହେତୁ ଚେଞ୍ଜ ହେଲା କେବଳ ଏଟା 2020 ରେ ଫାଇଲ କରିଛି। 2019 ପିଟିସନ ରେ ମୁଁ ସମସ୍ତଙ୍କୁ ପାର୍ଟି କରିଛି। ଟିକେ ଖାଲି
ମୁଁ କଣ ଭାଇ ଇଣ୍ଟରପୋଲେସନ ବା ଏଟା କଣ ଯୋଉ ରିମୋଟ ଚାର୍ଜିଂ କି?
ନା ନା
ଆରେ 20 ଆପଣଙ୍କର ପାର୍ଟି ନାହାନ୍ତି, ମୁଁ କେମିତି ଟ୍ରିଟ୍ କରି ପାର୍ଟି ବୋଲି?
ନା ନା ମୁଁ କହୁଛି 19
you are looking at some other thing. ମୁଁ 20 ଦେଖୁଛି, ମୁଁ ଦେଖିଲା ପରେ ଆଜ୍ଞା ଡିକ୍ଟେଟ୍ କରୁଛି। ମୁଁ ଯୋଉ ପଚାରୁଛି ସେଟା ପଢିକି କରୁଛି ନା ଆଉ।
ନା ମୁଁ କହୁଛି 19
କଣ 19 ରେ ପାର୍ଟି କରିଥିବେ, ମୁଁ କଣ ସେଟା I am not saying, I am looking at 2020 WPC 1956 of 2020. ଆପଣ ଆଉ ଗୋଟେ ଧରିଛନ୍ତି?
ହଁ 19 ମସିହାରେ ସେମ୍ କଜ ଅଫ୍ ଆକ୍ସନ ରେ ମୁଁ କରିଛି, ଯେହେତୁ 20 ମସିହାରେ ସେ ପ୍ରମୋସନ ସେଇଥି ଯୋଗୁ କୋର୍ଟ କହିଲେ କି
today the 2019 is I am not looking at, that is the second matter.
2019
So kindly look at 1956 of 2020.
मते
ଆପଣ ଏଇଠି ଦେଖୁନାହାନ୍ତି
हाँ मते अमेंडमेंट करियो पड़े एटा जदी जिबे लॉर्डशिप अमेंडमेंट करियो पड़ियो किंतु मु खाली देखे
ମୁଁ
दउची
କେମିତି how I will take it up ମୁଁ ବି ବୁଝିପାରୁଛି
मु खाली टे देखि दउची
ଆରେ ମୁଁ ଦେଖିଲି ସେଇଟା ମୋ ପାଖରେ ଅଛି ଆପଣ ବୁଝିପାରୁନାହାନ୍ତି ବୋଧେ ମୁଁ ସବୁବେଳେ ଖୋଲି ଦେଇ ପାରୁଛି ଆଟ ଏ ଟାଇମ୍ 6ଟା ଖୋଲି ଦେଇ ପାରିବି
19 टा अछि ना
ଅଛି
19 टा रे
ଆପଣ ଯୋଉ ଥିଓରି ପ୍ରୋପାନ କରୁଛନ୍ତି ଯେହେତୁ 19 ରେ ଥରେ ପାର୍ଟି କଲେ ଆଉ 20 କି 21 ରେ ହେବେନି ସେଇଟା ମୁଁ ବୁଝିପାରୁଛି
କହୁଛି ସେଇ ଯୋଉ କୋର୍ଟ କହିଲେ ଆପଣ ତ
ଆରେ ଆଗ 20ଟା ସବୁ ଲେଟ୍ ଅସ୍ କମ୍ପ୍ଲିଟ୍ ଦ୍ୟାଟ୍
ଆଜ୍ଞା
ଆପଣ ତ ସେଇ ଦିନ ବି କରି ଦେଇଥାନ୍ତେ the day you carried out the added the director higher secondary education ସେଇଦିନ ସରି ଯାଇଥାନ୍ତା କଣ ଲେଖିଲେ the type copy of the cost title shall be filed. Copy of the cost title shall also be served on the council for the state. How much time?
2-3 दिन भीतर कन
The necessary steps be taken within 5 working days.
लिस्टिंग पे कन काउंटर से मन फाइल करिया कथा
Whatever. Sir, ଆପଣ ଯଦି ସେଇଟାକୁ ସେଇଦିନ କରି ଦେଇଥାନ୍ତେ ତ ସରି ଥାନ୍ତା ତାକୁ
से कॉपी किंतु देई देसी से मान न कले और सीट अछि लने जे
सर ଆପଣ କପି ଦେଇଛନ୍ତି ବୋଲି ବହୁତ ଥର କହିଲେ ମୁଁ ବୁଝି ପାରୁଛି
आज्ञा
କିନ୍ତୁ କପି ଦେଲେ ଯେ ମୁଁ କେମିତି କହିବି ଯେ କପି ତାକୁ ତ କହିପାରିବେନି
ठीक है
କଣ ଲେଖିଲି
नेक्स्ट
ଆପଣ ଟାଇପ କେବେ କରିପାରିବେ
मु
ମୁଁ ଆପଣ 5 days working days ଦେଇଛି ଆପଣ ଯେତେ ଜଲ୍ଦି କରିପାରିବେ
हां फाइल टा फेरी गले मु सांग सांग न ऑर्डर सीट आसी गले नेट रे मु सांग सांग कर
list in the week commencing
I have to file my counter grant support right.
5 वर्ष ला काउंटर फाइल
At the same time, I can also file counter for.
ଆପଣ ସେ other courts are imposing heavy cost
No, let
so
me serve a copy. I
you
will
expect me to impose heavy cost I will direct heavy cost
Sir, I'll take steps for filing counter in the meantime so that it can be hard.
what you do you ask them to file counter
Yes, I am asking.
indicating that they have to wait for 5 years
Later today, just today. No.
6 years now 6 years ହେଇଯିବ
Mubara already instruction achi from the earlier department. Now I cannot file affidavit.
By virtue of this order,
Yes, yes.
you can ask them to file counter. I have already said that higher education to be a party.
Yes. Then there are 2 letters in that. That is why I
What can be done, sir? Money. If you ask them to pay money, they will then deposit the cost in court. They will file counter.
Only I have to ask them.
6 years is not good time to counter. Fine.
No, yes, that is like yes. 2020 there is a instruction there.
We commencing केवे कले? 9/2/2026.
आज्ञा मु 5 दिन भीतर एटा ये कर जेमिति फाइल
आज करंतु सर टाइप करी करंतु बहुत कटाकटी हेलानी सेटा
आज्ञा फ्रेश कॉस्ट टाइटल मु गोटे फाइल
बेटर
आज्ञा से ऑर्डर शीट रिफ्लेक्ट हेले
तर एडवांटेज है जे दैट यूनिफॉर्मिटी भी रहबो
आज्ञा मु ऑर्डर शीट रिफ्लेक्ट
लिखिबे WPC 21306 of 2019 नेक्स्ट पैट सेम अपीयरेंस रहबो in view of the order passed in WPC number 1956 of 2020 the matter shall be listed together the matter shall be listed along with the said matter in the week commencing kete kale 9/2/2026 yes next
24
May please ma'am.
So Durgesh Narayan Ratha for the petitioner. Counter not filed.
Madam, the petitioner applied, counter not filed. Petitioner's father, while working as an aided institution, he died and he applied for the rehabilitation appointment, my lord. His death was occurred on 12th of 9th, 2013. He applied on 30th of June, 2014. A merit list was also prepared, shortlisted. The list was prepared on Annex 6, indicating the name of the petitioner.
Yes.
But there, that list was published on 2nd of December, 2019, my lord. 2nd of December 2019, the list was published.
After 5 years.
After 5 years. What has happened, my lord, since 20 rules came, they didn't consider that list of December 19. And they set up thereafter we approached this honorable in 2020, my lord. So notice was issued. So in between, my lord, development has been occurred.
25, 4-4-20-25.
And the judgment of the Honorable Appeals Court, Madam Rita Loa. All the application to be considered in view of the 19. So only grievance is that one.
But that is is it a single bench matter?
My lord, my application is pending. This is a fresh.
No, so you go through that division bench order where I am a party to so many orders. So if you agree, both of you, and passing it over, that order will be passed.
My lord, I have the copy, my lord. But
সেটা ଟିକେ কিন্তু ক্যারি আউট করে তাଙ୍କୁ ଦେଖାନ୍ତୁ
ସେଥିରେ କିନ୍ତୁ ଷ୍ଟେଟ୍ ଆସିଥିଲେ ଅପିଲ ରେ
ସେଇଟା ତ
ଚେଞ୍ଜ ହେବ ସେଇଟା
In view of the Supreme Court judgment.
Supreme Court judgment 2025 সেটাକୁ ଆପଣ spend some time and I'm passing it over ଆପଣ ସେଟା କରିକି ତାଙ୍କୁ ଦିଅନ୍ତୁ but because he is busy he will be handling the next case so ଆପଣ କରିଦିଅ ତୁମର
ମୁଁ କରିକି ଆଣିଥିବି ତାଙ୍କୁ ଫାଷ୍ଟ ଆଜ୍ଞା
So it is the appearance like directly. Mr. Durgesh Saran author for the petitioner. Mr. P.K. Sahoo, additional standing counsel for the opposite parties. It is submitted by the counsel for the petitioner that after the father of the petitioner unfortunately passed away in the year 2013, he had applied for appointment under the applicable rehabilitation assistance rules in the year 2014. A merit list was prepared and that was published in the year 2019. What the year sorry, the state away since I'm repeating better 2019 during pendency of the writ application since 2020. The further development is that on 4/4/2025, the OCS RA rules have been amended. It is submitted that the petitioner's case, if considered in the new regime, the petitioner will not pursue the present litigation and await the result of the consideration of his case in the new regime. The additional standing counsel endorses the fact that the OCS RA rules have been amended with effect from 4/4/2025 for further consideration of the matter. List for orders. Next week hello এই week রে
না 27
list of the week commencing 27/1/2026. So whatever was there in that but only difference is that they went to Supreme Court directed then pending cases. So those things have to be only the operative paragraph can be there.
खाली operative पर more this is a fresh टा
or today I will dispose of Mr.
Some application is pending.
Lots of can dispose of in view of the Supreme Court judgment. There is there that they have to be considered as per the amended rule.
The Learned Counsel for the petitioner cites the decision of the Honorable Supreme Court. In the reference
State of Odisha versus Jita Luha.
Jita Luha ଅଛି କପିଟା State of Odisha versus Jita Luha. SLP number ଏତେ decided on ଏତେ
ଅଛି ଦେଇ
and further submits that the petitioner's case may also be considered as per the directions of the Honorable Supreme Court in Jita Luha. So it is further submitted by the Learned Counsel for the petitioner that several pending matters have already been disposed of by division benches as well as coordinate benches of this court in terms of the order passed by the Honorable Supreme Court in State versus Jita Luha, Supra. The reference should have ଅଛି Jita Luha ଅଛି division bench accordingly the writ application is disposed of directing that the petitioner's case shall be considered in terms of the new regime of the rehabilitation assistance rules that came into effect from 4/4/2025. तो rehabilitation लिखिए ना, पूरा ना लिखिए, OCS into bracket RA rules. For the state purpose, the earlier orders passed, if any, with reference to the case of the petitioner, are voided. आगुर किसी ऑर्डर पास से पड़ेगा स्टेट
नेक्स्ट 6 टा पेंडिंग আছে
अच्छा ସେଇଟା ସେ ଲାଇନଟା voided ତ କଲେନି if any ସେଟା କଟିଗଲା
ଅର୍ଡର ସାଙ୍ଗରେ ସବୁ ମର୍ଜ କରି
କିଛି ଅର୍ଡର କରନା ନହେଲେ ଆନେକ୍ସ 6 ଟା ସେ void
no division bench we pass this order then we are following this
the time limit
the case of the petitioner shall approach the ଆପଣଙ୍କର ହଉଛନ୍ତି କି employing authority
district education officer
approach the opposite party number 3 how much time within a period of 8 weeks
ना मु अप्रोच कर विदिन 10 days मु along
से पारिबेनी से
difficulty is a number of cases are pending as per the direction of Supreme Court they have to be
no cases
when they will come as per the
they are directed 500 rupees per day here I am not directing
because the number of
for days delay 500 rupees per day
रीट अपील आपण करते मु सर्टिफाइड कॉपी सहित एप्लीकेशन 10 दिन
within 3 weeks कर दिया तो so you may approach much earlier upon filing of the application along with certified copy of this order the OP number 3 district education officer Jajpur can do well to take necessary steps for considering the matter at his level, at his oblique her level, or shall forward the same to the appropriate authority for consideration for taking a decision in terms of the OCS RA rules 2025 amended with effect from 4/4/2025. The entire process shall be completed within 5 months. ଜିତଲ ଆପଣଙ୍କର ଅଛି ତ ଜିତଲ ଅଛି ସେଠି ଆପଣ ଦେଇ ଦିଅନ୍ତୁ
अरे आनेक्सर 6 टा टिके आ मो नाटा अछि सितरे कारण से आउ फ्रेश कंसीडर करियो फ्रेश मागिबे सर आउ डेली
पढि लिखिबेनी कोन लिखिले
मो नाटा अछि
जो कंसीडरेशन द अप्रोच कोन लिखिले पढिले आउथरा पिटिशनर सर filing of application along with annexure 6 original अछि अपन पाखरे
original टा
along with
ना original demo खाली
along with copy of the annexure 6
एरो वेबसाइट रे अछि
along with copy of the annexure 6 हां at hard level yes चलो रेस्ट ठीक अछि so upon annexure 6 author file kare jo application so clarified that the annexure 6 should be the basis of the initial consideration of the case of the petitioner due to as the matter is pending before this court since file 2020 and the annexure 6 is dated 2/12/2019
nice
yes annexure 6 टा पूराटा 6 series
annexure 6 टा लिस्ट समस्त को ना अछि मो ना भी अछि पेज 34 रे
annexure 6 with the enclosure as annexed to the read petition
आगा मु सब देती
yes next
25
Miss S Sahoo on behalf of SK Borala for the no adjournment for it order effective order तक इस दरकार नहीं पर posting कर दियो ठीक है yes next
26
Mr. Prakash Kumar Mishra for the petitioner
Lordship may see the last order.
Yes, dated?
Dated 13/10/2025.
Yes.
Wherein I have been directed to take instruction whether the original order has been assailed before this honorable court or not. Well, the matter is under valuation case, my lord. After under valuation order, a certificate.
It has subject matter with me. This is within my determination as a court.
Your lords, no, Stamp Act is assigned to court number 12.
So then I cannot take it up.
Malad,
This is a petition arising out of a valuation of stamp.
Yes, Lord.
Amount of stamp.
No, this present application is under OPDR Act, which is assigned to your lordship.
But upon original challenge
yeah, original is under Valuation Act, which is
challenge
which is pending. I have been asked to give the number in the previous order. I got the number.
The connection? Appearance selection. Mr. P.K. Sahoo, Additional Standing Counsel for the opposite parties, plural. Yeah. The Lord Counsel for the petitioner refers to the order dated 13/10/2025 passed by the coordinate bench and submits that he has obtained instruction that the order dated, the order ta kete, counter valuation order ta?
Order dated 25/2/2016.
Order dated 25/2/2016.
My lord, thereafter, two orders has been passed. One is
simple confusion over. You file a memo at least.
My lord, that is in the writ petition also.
Two paragraph?
Paragraph 17 and 18, your lordship.
Submits that? (17 and 18 kouchoti?
Yes, Lord.
Page
12 and 13, your lord. 12. Two appeals have been preferred. One is disposed of, dismissed on 20. The para 17 last line, my lord. The FAO number 3/66/7 of 2024 was dismissed on 25/2/2016, and another appeal.
Gote ago soru sir. Into kon dictation dehi hobo kisa bujhi hobo.
I guess.
That he has obtained instruction, and also as has been mentioned in the writ application, that upon date of the dinanti, order dated 7/11/2003 passed by the
7/11
district magistrate come
ADM come stamp collector.
Additional district magistrate come stamp collector Noyagad. Recording undervaluation of the document was challenged before the learned district judge
Noyagad
by filing FAO number
3 of 2004.
3 of 2004.
Subsequently, it was renumbered as FAO number 3/66/7.
Plus, page 12 dekhiye likhibe. Number bhul bhal heji ona. The appeal was subsequently renumbered as FAO number 03/66/07 of 2004. The appeal was dismissed by order dated 25/2/2016.
Subsequently, another
said order, FAO order ta challenge kale?
Say order along with another appeal was filed, my lord. In para 18, it has been stated another appeal by the FAO number 9 of 2021 filed assailing that 2003 order.
Kete thara challenge kale game ko
Say wrongly the thorough appeal filed kar dechan seta.
It is illegal.
Say sitpin res judicata ground second subsequent appeal has been dismissed on the ground of res judicata. And both the order of Hon'Ble
it is res judicata innovation. মানে যেদিন যায় দিলে হতো সেটা আপিল ফাইল হেই চালতো ସବୁ ମାସକୁ ଗୋଟେ 2019 ଗୋଟେ 21 ରେ ଗୋଟେ ଫେର 25 ରେ ଗୋଟେ
ସେଟା କରିବା କଥା ନୁହେଁ କିନ୍ତୁ
ନାଇଁ କରିବା କଥା ନୁହେଁ ହେଇ ପାରିବ ତ କିଛି ଲିଗାଲ ପ୍ରୋହିବିଶନ ନାହିଁ
ଆଜ୍ଞା
that's innovation
ଆଜ୍ଞା
କଣ ଲେଖିଲେ ସେଇଟା ଅର୍ଡରଟା ନୁହଁ ସେଇଟା ଅର୍ଡରଟା ସେ ସେଣ୍ଟେନ୍ସ ହିଁ ଭୁଲ ହେଇଗଲା
ସେ ଦିଟା
the petitioner again the petitioner chose to file appeal again, despite dismissal of his earlier appeal by order dated 7/11/2003 before the self-same authority, that is Lord District Judge Noagarh, by filing FAO number 9 of 2021. Light kiye pokele? It came to light. Pokele kiye light ta?
Despite dismissal of his earlier appeal by order of 7/11/2003, before the self-same authority that is Lord District Judge Noagarh by filing FAO number
9 of 2021. সেটা 16 কে কিন্তু ডিসমিসাল
না সেটা 3/10/2023 3/10/2023
and it is stop. It is stated by the learned counsel for the petitioner that the appeal for the second time challenging the self-same order was dismissed on the ground of res judicata by order dated 3/10/2023. তারপরে আপনার লিমিটেশন টা কোটু কাউন্ট হবো 21 না 23 রু
26 ରୁ 16 ରୁ ହବା କଥା
16 ରୁ ହବା କଥା
ହଁ 16
ନା লিমিটেশন টা অপিল অর্ডার টা কেবে কি
16 ফার্স্ট টা 16 রে সেকেন্ড টা
লিমিটেশন হবো
16 রে হବା କଥା
10 ବର୍ଷ ফাইল ଏବେ ଏଠି କେବେ ফাইল ହେଲା
ସବସିକ୍ୱେଣ୍ଟଲି
ସବୁ କୋର୍ଟରେ ଗୋଟେ ଫାଇଲ ହେଇଛି
ନାଇଁ ଆଗେ ଦିଟା
ଏଠି ଗୋଟେ ସେ ଆର କୋର୍ଟରେ ଗୋଟେ
ନାଇଁ ସେ ଓପିଡିଆର ଆକ୍ଟ ଆଉ ଇଏଟାକୁ ମିଶେଇକି ଗୋଟେ ରିଟ୍ ପିଟିସନ ଫାଇଲ ହେଇଥିଲା ସବସିକ୍ୱେଣ୍ଟଲି ଇଟ ୱାଜ
କିନ୍ତୁ ମିଶେଇ ଗଲାନି ସେଟା ଆପଣ
ସେ this honorable court pointed out that for that reason we
କେମିଷ୍ଟ୍ରି ଟର୍ମରେ ଇମୋସନ ହେଇଯିବ
ଆଜ୍ଞା ଆଜ୍ଞା ସେଇଥିପାଇଁ ମୁଁ ୱିଡ୍ର କରିକି
ଆପଣ କେମିତି ମିଶେଇବେ
ୱିଡ୍ର କରିକି ଏଇଟା ଫାଇଲ କଲି
ପ୍ରିନ୍ସିପାଲ ଏଗେନ୍ଷ୍ଟ ଆଉ ଗୋଟେ ରିଟ୍ ପିଟିସନ ଟା ତ ମିଶିବନି
ଆଜ୍ଞା ସେଇଥିପାଇଁ ମୁଁ
only
appeal for the second time, challenging the section order by dismissed on the ground of right to be by order section 3/10/2023.
free no ଆପଣଙ୍କ ବି ଭୁଲେଗଲା 3/10/2023 ଏତେ ଡେଟ୍ ହେଇଗଲା 3/10/2023 ଆପଣ କୋଉ ଏଫଓ ଚ୍ୟାଲେଞ୍ଜ କଲେ ପ୍ରଥମ ଏଫଓ ନା ଦ୍ୱିତୀୟ ଏଫଓ ନା ସବୁ ଏଫଓ
ଦିଟା ଏଫଓ at a time ଦିଟା କର
now the petitioner has filed ଏଟା କଣ ସେକେଣ୍ଡ ଅପିଲ ହବ ଏଠି ନା କଣ ହବ
ନାଇଁ ସେ ରିଟ୍ ହବ
has filed writ petition WPC number
336667 of 2020-25
3377 na 667 3367 of
2025
mano challenging the first order dated 25/2/2016 as well as the second order 3/10/2023 passed by the Lord District Judge Noagarh,
which is pending.
Stay here or stay in?
No, stay here, pending.
The said FAO, the said writ petition is pending before the assigned bench. Para. Challenge to the order passed by the Lord District Judge in the FAO is not a determination of this bench. Whereas the matters pertaining to OPDR Act is within the determination of this bench. ତାହେଲେ ମୁଁ କଣ କରିବି ତାହେଲେ କୁହନ୍ତୁ ମୁଁ ଡିସିଜନ ଭଳିଆ ବାରମ୍ବାର ଶୁଣିବି ନା କଣ
ନା ଏଇଟା ତ ଡିଫରେଣ୍ଟ ବଟ୍ ରୁଟ୍ ଇଜ ଦ୍ୟାଟ୍ ସେଇଟା
କଣ ଆପଣ ତ ଅରିଜିନାଲ ଚ୍ୟାଲେଞ୍ଜ କରନ୍ତୁ OPDR cannot sit on the appeal of the FAO or the ADM.
Kintu if under valuation order will go, then OPDR proceeding will go. So that is the root of the matter.
ଆପଣ ତ ରୁଟ୍ ମୋଟା କରିକି ଚାଲିଛନ୍ତି ଆପଣ ସେଟା କାଟିଥାନ୍ତେ ପ୍ରଥମରୁ ଆପଣ ରୁଟ୍ ରେ ସାର ଦେଲେ ବଢେଇଲେ ପାଣି ଦେଲେ
I consider for that reason.
But it's a good legal strategy. It is innovative. ସବୁ ବର୍ଷ ସବୁ ମାସରେ ଗୋଟେ ଗୋଟେ ଫାଇଲ କରିବେ ସିଆଡେ OPDR ରିଟ୍ ଫାଇଲ ହେଇଛି ଏଠି ବର୍ତ୍ତମାନ ଏଥିଓ ଏଗେନ୍ଷ୍ଟ ରିଟ୍ ଫାଇଲ ହେଇଛି ସେଠି
ନା ଦିଟା
କୋଉଟା ରହିବ ଧରନ୍ତୁ ସେଟା ସେଟ୍ ହେଇଗଲା ଦ୍ୱିତୀୟଟା ରହିଗଲା କି ଆପଣ ଆଗ ରେଜୁଡିକାଟା ସେଟା ସେଟ୍ ହେଇଯିବ ଆଉ ଥରେ ରିମାଣ୍ଡ ପାଇଁ ଯିବ ରିମାଣ୍ଡ ହେଇଯିବ ଧରନ୍ତୁ FAO can be remanded also possible.
That may be possible.
It will be remanded to the ADM.
That may be.
In such situation, the matter stands adjourned. Liberty to mention.
Interim order is there, my lord.
Interim order passed by the coordinate bench by order dated.
Order
23/11/2023.
23/11/2023.
Shall continue in the next date of hearing. से ओपीडीआर हे परिवन से गोतन से जमीटा भी आउतरे बिक्री हे सारी बनी
ना बिक्री
बिक्री हे परनी कहना से कबलाटा रजिस्ट्रेशन डेटटा हे परलानी बोली
रेजिस्ट्रेशन हे जाइए रेजिस्ट्रेशन हे जाइए आफ्टर रेजिस्ट्रेशन
रजिस्ट्रेशन पर आपण अंडर रिलेशन स्टाम्प केस चल
आगे
यस आपण हेडा केबे लिस्ट पे अछि सेटा चापी दैछन
एक्चुअली आई एम नॉट काउंसिल इन दैट योर लॉर्डशिप में पेरुस
दैट इज अनदर रेगुलरिटी
नहीं से
so each case by a different counsel
नहीं मु
because district judge one counsel cannot file two appeals in before arising out of one order so सेटा भी से दिटा अलगा हितो नल तो सेटा मिसकंडक्ट हे गला
नहीं मु इनिशियली आई
जो पाखरे जे नायगढ़ अपील करथिबे आपण कोन दिटा फाइल करिवे गुटे ऑर्डर केबे हबनी
मो जानि सेटा
हितो कौन से कौन लिखली जोटा लिस्टेड इज नॉट डिटर्मिनेशन सेटा होची कोई कोर्ट रे
से कोर्ट नंबर 12
एट प्रेजेंट
जस्टिस ऑनरेबल जस्टिस शशिकांत मिश्र स्टैम्प फैक्ट
असेंट बेंच रे अछि सेटा यस नेक्स्ट
ऑब्लाइट
27
So Patnaik is not visible. You are from his office. Your name, sir? Satyavrata Mahapatra. Mr. S. Mahapatra, you are writing. Mr. Satyavrata Mahapatra for the on behalf of S.K. Patnaik for the petitioner. Mr. S.K. Mishra for the opposite party. Yes, what is the matter, sir?
Your Lordship, I have received the counter on 15th of this month. And I will seek instruction whether to file any rejoinder.
Learned counsel for the petitioner submits that he shall obtain instruction in response to the counter filed by the opposite party and seeks that submits that. And the matter may be adjourned. Accordingly, the matter shall be listed. How much time? 2 weeks. Don't. ठीक अछि डेट कोंतु 2 वीक मागुचन
23
लिस्ट इन द वीक कमेंसिंग 23/2/2025
My lord, in this case, my lord, I have filed that counter in e-filing. It was not tagged with the file, my lord. The thing is that
submitted by the counsel for the petitioner opposite party that the counter was filed was e-filed on
15/1/26.
On 15/1/2026, copy has been served. The registry shall locate the copy of the counter and scanned copy be updated. Okay? कोर्ट में पास हो रही थी एटा इनफ्रुक्चुअस ना कोर्स पळेले आइटम 10 कॉल कर दो ना
आइटम 10
yes, you are there. Yes. You are saying that cause of action no more survives.
Yes.
Okay.
I've given the
Item 10 lekho. Your name?
Sir, I'm Mr.
Bracket रे आपण नाडा पूरा लिखि दियो.
Yes.
Because Sorry, ଆପଣ ନାଁଟା ଆଉଥରେ କହିଲେ?
My lord, I am Mr. Nilanchal Samal.
Mr. Nilanchal Samal.
Yes.
So, N. Samal on behalf of Manas Ranjan Samantray.
No, your lordship, it's for
ନୀଳାଞ୍ଚଳ ମାନେ ଆପଣ ଯୋଉ ପୁରୀ ନୀଳାଞ୍ଚଳ ନୁହଁ, ଅଞ୍ଚଳ ନୁହଁ, ନୀଳ ଅଚଳ।
yes.
ଓଡ଼ିଆରେ ମିଷ୍ଟେକ୍ କରନ୍ତୁ।
Yes.
ଆପଣ ନୀଳାଞ୍ଚଳ ଲେଖୁଛନ୍ତି?
And no, I actually I pronounce it in English as Nilachal Samal, but then in Odia it becomes Nilanchola Samal.
ଓଡ଼ିଆଟା ଭୁଲ।
Yes.
In Odia it is ନୀଳାଚଳ।
Yes.
ନୀଳାଞ୍ଚଳ ନୁହଁ।
In English it would
ନୀଳାଞ୍ଚଳ ଅର୍ଥ କଣ ହବ?
it would be Nilo Otoizu Anchola. Like the sky, like water or something. That's what
ନୀଳ ଅଞ୍ଚଳ, ନୀଳାଞ୍ଚଳ ହବ। ନୀଳ ଅର୍ଥ ହିଁ ନୁହଁ। ତ ଅଚଳର ଅର୍ଥ କଣ, ଅଞ୍ଚଳର ଅର୍ଥ କଣ?
Ochola is it like non-functional and Anchola is a place.
ପାହାଡ଼, ମେରୁ, ମହାମେରୁ। ଅଞ୍ଚଳ?
Anchola is a region.
ଆଉ କଣ?
ଶାଢ଼ୀ ଆଞ୍ଚଳ।
ଶାଢ଼ୀର ଆଞ୍ଚଳ ହଉଛି ଅଞ୍ଚଳ। ତ ପୁରା ଅର୍ଥଟା ପୁରା ଅଲଗା ହେଇଯିବ। ସେ ଯୋଉ ପର୍ବତ ଯୋଉଟା କି ନାହିଁ କି ଯୋଉଠି ଅଛି ବଡ ଦେଉଳ, ସେଇଟା ହଉଛି ନୀଳ ପର୍ବତ। ନୀଳ କନ୍ଧର ବି କହୁନାହାନ୍ତି କି, ନୀଳ କନ୍ଧର, ନୀଳ ପର୍ବତ। ସେଇଟା ଆଗରୁ, ପର୍ବତଟା ଆଗରୁ ଥିଲା, ବହୁତ ଆଗରୁ ଥିଲା। ଆପଣ ଯଦି ପଢିବେ ସେ ଇଏଟା, ଅଞ୍ଚଳ ସେଟା ନର୍ଥ ଇଣ୍ଡିଆରେ ଯାଇକି କେମିତି ହେଇଗଲା ନୀଲାଞ୍ଚଳ ଏକ୍ସପ୍ରେସ ହେଇକି, ତାପରେ ସେଟା ବଟ୍ should be pronounced correctly. କାହିଁକିନା ଆମର ଗ୍ରାମାଟିକାଲି ଇଏ ଭେରି ମାନେ ଇଏ ଷ୍ଟ୍ରଙ୍ଗ। ସେମ୍ ଇନ୍ ସାଂସ୍କ୍ରିଟ ଅଲସୋ। ନୀଳାଚଳର ସଂସ୍କୃତ ଯାହା, ଓଡ଼ିଆ ବି ସେୟା। ଆପଣଙ୍କର ସେଇ ତାଙ୍କର ଯୋଉ ସ୍ତୋତ୍ରଟା ଶୁଣିଥିବେ ବି।
ନୀଳାଚଳ ନିବାସ।
ଆଉ କେମିତି କହୁଛନ୍ତି ତାହେଲେ? ଆପଣ ତ ସବୁ ଜାଣିଛନ୍ତି। Yes. Mr. Nilachala, Manas Ranjan Samantray. The Manas Ranjan Das. ଆଗରୁ ମାନସ ରଞ୍ଜନ ସାମନ୍ତରାୟ ରେକର୍ଡରେ ଅଛନ୍ତି ତ, ନା ଏସ୍.ଏନ୍. ବିଶ୍ୱାଳ, ଶିବନାରାୟଣ ବିଶ୍ୱାଳ?
Our office, yes, Manas Ranjan Samantray.
Mr.
No, he's other side.
Petitioner?
If Manas Ranjan Samantray is other side, then
No, Das is on the other side. Samantray, both are Manas Ranjan.
Yes.
ଆପଣ ହଉଛନ୍ତି ଅପୋଜିଟ୍ ପାର୍ଟି ପାଇଁ?
Yes, your lordship.
Opposite party blank, opposite party none. So I got confused with that, both the names being same. So when you said Manas Ranjan, I got confused. Hello? Opposite party, petitioner blank. Hello? Opposite party, Mr. Nilachal Samal on behalf of Manas Ranjan Das for the opposite party. The Lord Counsel for the opposite party, Mr. Samal, submits that he has instructions received from the opposite party that during pendency of the present petition, the CP number, the CS number, so that the memo ta jata hai. The CS number 71 of 2024. Copy টা নাই না 105 এটা কোড মোড ফুল ফাইল আছে ওর ঠিক আছে the CS number 105 of 2011 earlier pending before the Lord civil judge into bracket senior division Titilagarh, which was sought to be transferred to the court of appropriate jurisdiction at Bhubaneswar, Khordha, has been disposed of. Memo stating the said fact is filed. Memo of date stating the said fact is filed by the Lord Counsel, Mr. Samal, which is taken on record. According to the right, adjudication in the present petition. The petition is disposed of. Meeting.
Okay.
Twenty-eight also same order खाली change हो. CP number 140/2024 जज फैमिली कोर्ट जगतसिंहपुर 28 लिख ले ऊपर जोटा ऑर्डर एग्जैक्ट 10 जहाँ 28 भी सेम बढ़िया हो तो लिखिए 28 रे अपीयरेंस लिखिए मिस्टर रमेश चंद्र स्वाई फॉर द पिटिशनर मिस्टर बिरजा प्रसन्न दास फॉर द अपोजिट पार्टी तापर लिखिए कॉपी ऑफ द copy of the memo filed by the learned counsel for the petitioner. Enclosing copy of the affidavit dated 28 28/2/25 passed by the filed before the learned judge family court Jagatsinghpur in CP number 140/2024 is taken on record. Scanned copy be updated. Item 10 लिखिए copy of this order shall be forwarded to the learned judge so and so. See judge to be kept on record tagged to the case number. Clear? And out पूरा डाकी देगी. ठीक है जहाँ थी वो हाँ सत्तर CS सत्तर CP 25 रे सेल एंड कहते 28 लिखिए फिर Yes, next.
29.
Posting कर दो 29. Time है.
30.
30 रे आपनकर इफेक्टिव ऑर्डर ना खाली पोस्टिंग है पोस्टिंग कर देबे वो तो इफेक्टिव ऑर्डर नहीं ताको समय अतिबाहित करन से 31 yes Mr. Mahapatra
Sure.
Simple posting order
Minor.
yes mane he is posting I am not passing any order I mean to say that yes next Mr. Dal
Minors.
32
minors.
I filed my counter. I have already solved the.
you take a date
Yes. I filed.
time is not available so I will not pass orders
I filed the agenda.
yes to mention which I am calling the list तापर next
33 टा posting.
हाँ ठीक है
Interim order to confirm.
Mr. Swine 34 take a date
subject file with the opposite partner appearing in this
possible no difficulty
yes ma'am
I mean whatever is possible according to the board of the court so it will be done big date दे देवे 34 35 madam
35 issue notice to the opposite parties
तो ही चिता पर ସେମାନେ appear करछंती
ना
तो ना बाहर चिना को
ना बाहर
so take a date let us see because I will not pass a order after the court proceeding is over 35 date कर देवे
36.
posting रो देहिची खाली
खाली posting counter टा असला section टा संगे लगेगी section रा
आसिला बे मन लगे देवे स्कैनिंग में पठे देवे yes 37 टा दियंतु Mr. Manas Ranjan Dala for the petitioner Ms. Dipali Mahapatra for the opposite party same order as in 10 disposed of এটা কোড পাইবে কইলে এটা ଆପଣଙ୍କର ତା flag ରେ ଅଛି flag B 37 ରେ flag B ରେ next
38 39
38 ରେ interim order to continue कर देबे 38 Mr. J Sahoo for the petitioner Mr. Devasis Sahu for the opposite party counsel for the petitioner 6 the opposite party for the for the opposite party seeks accommodation. Accordingly, the matter shall be listed in the week commencing 16/26. Interim order passed earlier shall continue. Date interim order dated so and so shall continue till the next so and so. Next date of listing. Yes.
39 is simple as well.
Yes. 40 the not reached. जहाँ अपन posting कर देंगे.
Your Lordship, for item number 40, the mediation procedure has come out.
Unsuccessful.
Unsuccessful.
So let us see.
Your Lordship.
Pass over किसने?